All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston within the Commonwealth. Draw near, give attendance, and you shall be heard. Now sitting in the Commonwealth of Massachusetts, court is open, please be seated.
Good morning, everyone. This is the January 6th session of the Appeals Court. We are your panel for today. On my right is, I'm John Englander. On my right is Judge Hodges. On my left is Judge Smyth. We have 6 cases on. We will take a break after the 3rd case. I anticipate we have plenty to do today. As those of you who have been here before know, it's 15 minutes per side. There is no rebuttal. And because we have plenty to do today, and in any day, if you've been here before, you know that we've read the briefs, we've read the pertinent materials, we're ready to go. We will have questions. It's best for counsel to cut right to the chase. And so, without further, the first case is Commonwealth against Thomas, 23P 1442, and I think we're hearing from the Commonwealth, right? Mr.
Correct,
Hansen?
Your Honor. If it pleases the Court, Arna Hans for the Commonwealth. Your Honor, the Commonwealth filed this appeal because the district court judge allotted 244 jail credit days that he should not have allotted to this defendant. Brief background, Your Honor. The defendant had 2 open cases, one in Stoughton, one in Brockton. We're dealing with the Brockton case here. During the pendency of those 2 cases that overlapped, he ended up serving 244 days as a result of multiple revocations from the Stoughton case. He ended up pleading the Brockton case first, got a continuance without a finding for 6 months, and subsequently, a couple months later, pled the Stoughton case to 244 days of jail credit. Those 244 days encompassed the entire time that he was...
Yeah, I think we've got the facts. I mean, the question is, doesn't the judge have the discretion to award those days? Why doesn't the judge have the discretion under our case law?
So the judge cited fundamental fairness in the interest of justice. Now, I think the case law is very clear. The Pearson case from 2019 states it exactly, that if you're double crediting the jail credits, fundamental fairness doesn't apply. And that's comes straight from Pearson. Because he got the 244 days in Stoughton, the Judge Palmucci couldn't rely on fundamental
Which case
fairness.
are you relying on, Pearson?
Correct.
And basically your argument is a matter of law, even though we have cases. Do you agree the cases suggest, more than suggest, state flat out that the judge has the discretion to award, to double the credit, if you will?
There is a statement that says that, but...
In an SJC opinion, as I recall. Ridge?
Yes. So, but the circumstances here don't fall in with that if you read the Pearson case the way that the Commonwealth does.
Oh, so what does Pearson say? What are the facts of Pearson that mean? Because what you're saying is the judge erred as a matter of law, even though I've got a case here that says, I think, to be sure, had the defendant requested credit for his pretrial detention at the time of the Plymouth County sentencing, the sentencing judge plainly would have had the power to accede to or to deny the request. Well, why do I ignore that language?
Because there's a history of case law that says the opposite as well, that it doesn't, fundamental fairness doesn't apply in these circumstances.
Well, it doesn't apply. In other words, he's not entitled to it. Is that what you mean?
Yes.
Okay, but that...
If you look at Pearson, what Pearson says is if you're held in custody and you have 2 open cases, you can only apply those credits to one of those. And that is echoed in a long history of cases that preceded Pearson, including Foley, Barton, Blakey, as well as Murphy and Harvey, all of which are cases that I cited in my brief. And the common factors in all of those cases, because they bear similar fact patterns to the case at bar, is the defendant has 2 open cases and he's in custody during the pendency of those cases. One of those cases ends up being resolved first, whether it's through a plea or a trial. The jail credit ends up being applied to that first case. Then the second case ends up in a conviction further down the road, and that defendant then says, hey, I'm entitled to these credits again, and the court has consistently found that that is not the case, that you can only apply it to one of those cases, and that's exactly where we are here.
As a matter of entitlement. What were the facts of Pearson? I have it in front of me, but I don't have, the facts of Pearson, oh, Pearson is the crime spree guy, right?
Correct. He did multiple
He does a
armed
whole
robberies.
bunch of crimes in Middlesex County, and then he goes over to, I forget, Essex County, and does the same thing, right?
Correct. Now, I could go through the facts of all of these cases, but it's all the same fact pattern.
Right, but I mean,
I think
folks on either side of me are much more experienced with this kind of thing than I am. But here's my reaction. Why are we here? The judge could have said on a Rule 29, I'm reducing his sentence by 244 days. He would have had the discretion to do that, right?
Correct, but that's not what happened. And I agree with the court. He could have he sentenced him originally. If you sentenced him to 60 days, you could have done the 60 days deemed served, and that would have been well within his discretion to do so. Instead, he did a year.
Is there something I'm missing as to why there's a significance or a difference between the judge saying, I'm going to give him jail credit for 244 days and saying I'm going to reduce the sentence by 244 days on a Rule 29?
No, Your Honor. Unless the court has other questions, I would rest on my brief.
Well, let me ask you this, because assuming we were to agree with you that the judge should not have given double credit, isn't the fact that he said, when he said the sentence shall be deemed served, isn't that essentially just a resentencing? In other words, his reason for the resentencing may have been incorrect, but he has broad discretion in the sentence he imposes. Because as I read this, it just looks like he changed his mind because he gave him the maximum sentence on the probation revocation. He then changed his mind within a very short time after and seemed to be reaching for a reason to say, I want to impose a different sentence, and he hung his hat on this sentence credit thing. But even assuming he was wrong in that, he still had the discretion to say, I'm going to revise and revoke the sentence to time served. Would you agree with that?
Yes, Your Honor.
And if that's the case, then we'd pretty much be bound to affirm what he did, right?
Yes.
What is the Rule 29 was the wrong mechanism for this, right?
I think that's why we're here, that the judge could have ultimately come to this, but he went about it the wrong way.
Well, if he'd asked for a change to the minimus, that's what all these other cases are. I'm afraid that I'm a little out of my depth in terms of the exact process, but the usual motion here would be, or if you want to change jail credit time, would be a request to change the minimus, right?
Yes, I mean, that would be the result that the Commonwealth is asking for if the court were to agree with the arguments that the Commonwealth is putting forward, that this would be a correction of the minimus, and with respect to the jail credits allocated, that he essentially, the minimus would have to be corrected to reduce his sentence by, or the time served by 244 days.
All right, and I have one other question, which is, I think your opponent makes this point, but he says, look, your appeal is moot. But you have multiple appeals here, right? Because the judge went back and on a, how did this work? I'm trying to remember. There was an order, and then he revoked the order and basically reinstated the order, right? And the Commonwealth kept taking an appeal from each one of those orders. Is that what happened?
Yes, there are two notices of appeal filed, one on October 31st after the first motion to revise and revoke, and then a second one on November 22nd after the second motion to revise and revoke.
But he had no jurisdiction to address the second motion, did he?
That is my argument on appeal, which is
Yeah.
why it's not moot, because Commonwealth had filed its notice of appeal, and prior to him acting on the second motion.
Are Rule 29s, I have this vague memory that Rule 29s are an exception to this issue. I mean, generally, once a notice of appeal is filed, there's no jurisdiction in the trial court to address motions having to do at least with that subject matter, right?
Yes.
Is there an exception for Rule 29s that would allow somebody to serially come in and have their sentence revised?
I don't have the answer for the court. I would have to look that up.
So let me just ask you this. What relief is the Commonwealth really seeking here? Are you asking for us to say the judge just got it wrong as far as the application of the sentence credit? Or are
Correct.
you asking for something more than that?
No, the Commonwealth's argument is that the judge abuses discretion by giving the defendant 244 days that he was not entitled to, because those 244 days were his Stoughton sentence. And those 244 days that he was held in custody pending our Brockton case, he was just not, he can't double dip. So we're asking that those 240, the minimus be corrected. Instead of saying he served all 365 days, he in fact served 121 because he got 244 that he wasn't entitled to.
And the consequence of that would be he has to go back, he's subject to being rearrested and placed back in jail
Yes,
for 244 days.
yes.
Now, I find it interesting that the jail didn't kick this back as it did the prior sentence, right? In other words, the whole reason that the Commonwealth went back before the judge was because the jail had said you're awarding credit that you can't award, right? Isn't that what kind of started this whole thing?
I wasn't involved at the onset of the case. I'm second counsel on this, so I just couldn't, I don't know the details of what happened prior to. I became involved at the reply brief stage.
Okay, but in any event, the jail did not kick this back.
I don't believe so.
Thank you.
Thank you.
Good morning, Your Honors. Attorney Jason Howard on behalf of Mr. Thomas. This isn't a statutory entitlement argument that trial counsel made for the credits or that I'm making on appeal. I recognize the case law regarding the statute application to this case. But Commonwealth Ridge, which I suggest is directly controlling, says that although you may not be statutorily...
Dicta in Ridge? Is there any other case that affirms a situation like this where there's clearly a double dip, right?
There is clearly...
Double dip.
Right.
Yeah, your guy got
He got
an 8-month break.
He received leniency from the trial court, sentencing judge. There's no question about it. But so to your primary question, yes, because Pearson, that the Commonwealth speaks of, and then Leiden thereafter, it's not often that you get it, that you get the double credit under Ridge. But Ridge, that SJC opinion, says that, to be sure, had the defendant requested at the time of sentencing to the sentencing judge, the judge had the authority or the discretion to apply it. Pearson comes subsequent to Ridge. Pearson acknowledges the holding in Ridge. The issue in Pearson, and it's clear in the footnote of Pearson, they say this is not a question of whether or not the judge had discretion. It's footnote 4 or 5 or 6 in Pearson. What Pearson says is that under the circumstances of the case, he's not statutorily entitled. And the whole debate in Pearson was whether or not the Norfolk County cases and the Middlesex cases were related offenses, because the gentleman or the defendant in Pearson, every case has a multitude of facts, but let's just say in Pearson, the gentleman resolved Norfolk County, got all the credit that he was held pre-trial on both Norfolk and
Footnote 6.
Yes. He says, look, your defendant in Pearson is making a statutorily entitlement, trying to merge the Norfolk and Norfolk and Middlesex cases together to make them related so that under the statutes and the case law interpreting the statutes, he gets the benefit of the statutory entitlement. Pearson was clear that the defendant did not, at the time of his sentencing, I think it was like 5 years later, he filed a motion to correct the minimus. He said, oh no, you didn't ask for it at the time. Or, I don't know how
Should your
much.
motion have been entitled a motion to correct the minimus or a Rule 29? Does Rule 29 apply?
Yes, it does. It can apply. It may not be the best method to do so, Judge, but in my opinion, Rule 29 says that the judge, so long as it's within 60 days of the sentence, so,
Which is true, right? This was within 60 days.
yes, Judge, and so long as the judge is considering only facts that were ascertainable at the time of sentencing. And so if we look at September 25th.
Right, but there's another word in there, right? It's like change the, may adjust the sentence. This judge didn't adjust the sentence,
Well,
right? And look, I don't have it in front of me, I should have, but is there a case that says Rule 29 applies to this, to an adjustment of jail credit?
is there, I'm not so sure that the cases that come before the court on these jail credits, they usually are by,
Minimus.
the motion to correct or a motion to award jail time. You usually mail it to the clerk takes the first strike at it, you run it by the House of Correction, and they say, look, we only have 91 days on, be that as it may, there's nothing, in my opinion, Judge, nothing precludes the judge at sentencing.
Maybe the language of the rule?
Nothing,
So, I mean, it's the same question, it's sort of the flip side of the question I asked your opponent. You know, I mean, the judge could have, I think, on a Rule 29, said, yeah, I'm going to knock 8 months off his sentence. I've decided that the proper, I have the wrong sentence here. Part of it's because he's been sitting in jail, you know, pre-trial and on another charge, but I'm going to reduce the thing by 8 months. And I think then the judge has the discretion to do it, but that's not what happened, right?
so it's many different ways to look at the same outcome, Judge. I mean, the judge says, and I know you know the facts, but the judge, trial counsel at the time of sentencing says, hey, Judge, I'm looking for 70, I don't know how they got their math. Lawyers doing math. But he says, Judge, I think he's got 9 months out there in Stoughton that I think he's entitled to. Judge says, look, I'm not going to do that on the fly. I encourage you to file a motion to revise the sentence when you've got the numbers.
The judge says do a Rule 29.
And so with respect, Judge, and so trial counsel who he files the motion and in the body of the motion, he follows all the parameters of Rule 29 within 30, supported by an affidavit. These are the facts that were available at the time. And the judge says, in my opinion, Judge, in the exercise of discretion, which he has, you know, he has the authority to do, the ability to do, whether we would have agreed with him or not, whether my client got a sweet deal from the judge, the fact remains he had, in my opinion, he had the discretion.
Yeah, but even the House of Correction flagged it as, we can't do this. The
Well-
sentence isn't legal. So, I mean, shouldn't that give everybody pause that we can say discretion all we want, but there are limits to discretion?
Well, with respect, the counsel at the House of Correction, they're not, you know, they're not members of the judiciary, right? So they're keeping track of the time that my client is in the House of Correction, and they see the 91 days. They see the 51 days that were a Brockton District Court revocation of my client's bail on that charge, as well as the period of time he was held in detention.
Right, they recognized it as there's a double dip that's underway here.
Right, they recognized it as a double dipping, but that doesn't mean it's illegal. That just means they're flagging it, and the judge under Ridge has the discretion. He has the authority, not
Any
the...
other case besides Ridge? Any other case? Because Ridge it's dicta in Ridge, right? I mean, the court says, well, he could have done it.
Right, and then,
Not required to.
but I guess to your point, Judge, I haven't, usually it's the defendants not receiving credit who file these motions, and it's abuse of discretion. You know, we lose. This defendant won. So Ridge says what it says, wasn't necessary to the holding because...
The Commonwealth rarely appeals.
What's that?
You mean the Commonwealth rarely appeals this kind of problem?
Well, in mootness and double jeopardy, my client was deemed served, and there was no stay sought by the appeals court, and he's done his time, so we're going to...
I think they appealed. Look, you've got a problem there because when you first Rule 29, you may not, are you appellate counsel, not trial counsel?
I'm appellate counsel, not trial counsel.
All right, but so trial counsel filed a Rule 29, that was proper, got an order from the judge, that was proper, that was appealed. Once that's appealed, The jurisdiction lies in the appeals court. You have to get leave from us to file another motion, at least if it's on the same issue. Judge doesn't get to fix things after the appeal unless we let them.
I am with you, with one caveat, Judge. Filing the notice of appeal in and of itself does not give with respect, does not give the appeals court the jurisdiction on the case. It's once it's entered. If counsel in the trial court simply files a notice of appeal and takes no effort to perfect appeal, the appeal never comes before you all. So this case was not docketed, entered on the docket, granted the jurisdiction of the appeals court until December 15th of 2023. The notice of appeal, with respect, didn't remove the jurisdiction of the trial court. A and B, Judge.
Got any case that says that?
Yes, Kevin, footnote 4. I've got because I heard you, Judge, and
All right, we'll take a look at that.
Commonwealth versus Kevin. I didn't have a chance to respond to it because it was raised in the Commonwealth's reply brief.
Yeah.
400 Mass 557, footnote number 4.
All right, that's great. Thank you.
It's Mass Rule of Appellate Procedure. I think it's 9C when a criminal case is docketed on the appeal, docketed with the appeals court.
400 Mass.
557, 1987, footnote 4. And there's also Commonwealth versus Atkinson, and there's another one. I didn't write them all down.
There's no jurisdiction in this court from the notice of appeal. It's only once it's docketed.
Once it's docketed, Judge. A. B, motion to revise and revoke, you have a 60-day jurisdictional window. The sentencing judge always maintains authority over his sentence so long as it falls within Rule 29, 60 days. For example, during COVID, there were a number of questions about how individuals in custody could alleviate, get themselves out of custody. I think it was Commonwealth versus Charles in the CPCS decision.
Okay.
Talked about if you're within 60 days of Rule 29, if you're within 60 days of your sentence, file a motion to revise and revoke. If you have an appeal, file a motion to stay. So I believe, Judge, that the sentencing judge had the authority to entertain the Rule 29s and had the discretion to award that jail credit. My client wasn't entitled to it, I grant you that. But Ridge, Pearson, and Leiden, they all recognized, let's call it the dicta of Ridge. Pearson said, look, we see what he could have done. He didn't do it. He doesn't get the benefit of Ridge. I think Leiden was the one that came afterward, talked about nunc-pro-tunking sentences if you don't have the statutory entitlement to the credits. But Pearson...
What would you say if we acknowledge that the judge got it wrong as far as sentence credit, but we construed his saying sentence deemed served as a change in the sentence to time served?
Yes.
What would you say to that?
What I would say is that once the judge deemed that sentence served, he sentenced my client. He sentenced my client, and my client served that sentence. And with respect to say, we're going to simply change some numbers on a piece of paper and send him back to jail, he will then be compelled to serve a sentence that was deemed served. Then under double jeopardy, my client has the recognized interest and finality of having served.
Right, no, but what I'm saying is if we were to deem his sentence as being served,
yes,
as the judge said, then the case is over, there's no further sentence to be served, that's it.
Yes.
But the judge could still be wrong on the credit issue, right? In other words, your client would not be harmed by that. Unless I'm missing something.
Big picture is I'm saying my client, I started with a double jeopardy. I don't mean to suggest this is academic, but my opinion, Your Honor, is that my client was sentenced, deemed served.
Uncorrectable on appeal is your position. It's the grant of a Rule 29.
It's like the Ellison or it had to do with the one-day quaff.
There are very few things in this world that a trial court can do that are uncorrectable on appeal. That's your position on this.
There are things that
I really struggle with that concept.
Well, so for example, if a judge enters a required finding of not guilty
That's the one.
before the jury.
That's the one.
And
I don't know of any other.
Oh, this judge, this client's sentence was deemed served, and we have cases, Slovakia, Commonwealth versus Slovakia, where the gentleman was erroneously sentenced. I think it was on a child pornography case. He was required at the time to have mandatory GPS per the statute. The judge didn't impose it. And the SJC said, A, that was wrong, you should have imposed it, but B, because of double jeopardy, in the interest of finality, we're not going to put the gentleman on GPS because double jeopardy, we
Did they
can't.
say it was uncorrectable on appeal, which is your position?
Look,
Okay.
if the judge was wrong, he was wrong, but in terms of my client, retrospective application of it, double jeopardy would preclude, again, with respect, I'm not, would
I
preclude.
understand your position. I'll take a look. By the way, I couldn't see it in footnote 4 of that case.
Yes, Kevin.
No, I took a look.
Oh,
Yeah. it's
that's
not
the
there.
reply brief, because they raised the jurisdictional issue in the reply brief, Judge. They didn't raise the jurisdictional issue in their main brief.
Mm-hmm. Right.
I know there's a case on the docketing. I know there's a
You
case.
know what?
on-
That's okay. You don't need to solve it now. What I appreciate is how hard you're working to get it right, which is what we appreciate from council. So we can take a look ourselves, okay?
Yeah, and I'm wrestling with what the issue was that we were I had given you that citation because,
It has to do with the question of, I'm sorry, I've lost the thread too.
The jurisdiction question? Is
Yeah,
that-
it has to do with
Oh.
our jurisdiction.
I know I worked on an appeal, Commonwealth versus Atkinson, where once the appeal is docketed, the trial
Yes,
court is
that's it.
divested of
That's the
jurisdiction.
issue, yeah.
But until it's docketed, it remains in the trial court.
Okay.
Because we can file notices of
We
appeal.
can take a
never-
look at that.
Okay.
All right, thanks. Is there anything else?
Double jeopardy, please don't send my client back to jail. That's the big picture, Judge.
Okay. Very well argued on both sides.
you,
Appreciate it
Judge.
very much. Thank you. Next case is Commonwealth against Lopez, 24P 372. And counsel for Mr. Lopez, Ms. Chuna?
Chana.
Chana? Welcome.
Thank you. Good morning, and may it please the court. Rachel Chana on behalf of Mr. Lopez. I'd like to split my time this morning between the two issues raised by this appeal with this court's permission. With respect to the first issue, the immigration consequences of the charges Lopez faced were clear and certain. Trial counsel had a duty to advise Mr. Lopez of these consequences. His advice was constitutionally inadequate, and as a result, Lopez was deprived of the opportunity to make an informed decision based on accurate legal information about whether to proceed.
What do you say counsel should have said in 1999?
In 1999, counsel's duty was clear: to accurately advise Mr. Lopez of the clear and certain immigration consequences. Case law is clear that advising a client in probabilistic terms of consequences that may happen when those consequences are certain to happen is deficient.
Consequence of what? Consequence of going to trial and getting convicted and getting sentenced, or consequence of going to trial, getting convicted on a lesser included offense and getting sentenced, or consequence of pleading guilty, or pleading guilty to a lesser included offense? What do you mean by consequence?
Counsel has a clear and unequivocal duty to advise a non-citizen client of the immigration consequences of a conviction. This is clear.
Whoa, but see, that's a lot of words, and it's not an answer to the question I gave. Where I started is, what should this lawyer have said to your client? What do you say he should have said?
Okay, I apologize for misunderstanding
but
your
it's
question.
important. I mean, you've got two interesting issues here, but unpacking them is not that easy. And you heard some of that in Judge Hodges' question just now. What do you say should have been said?
Okay, With respect to the first count, assault and battery, counsel's advice was objectively wrong that this could carry adverse immigration consequences for Mr. Lopez because assault and battery is not a crime of moral turpitude that endangered Mr. Lopez's most important priority of remaining in this country in any way whatsoever.
See, what do you say he should have said?
And so, therefore, he should have advised Mr. Lopez that assault and battery would not carry immigration consequences. He also had a duty to advise Mr. Lopez that the other two counts with which he was charged would certainly render him deportable and inadmissible under no uncertain terms.
That wouldn't be very good advice.
Excuse me?
That wouldn't have been very good advice. Your client was deportable. Your client was undocumented. Why would he say, oh, if you get convicted of this, it renders you deportable? He was already deportable. That wouldn't be good advice, would it?
That would not have been complete advice. I didn't get to finish my sentence, Your Honor. He was also required to advise Mr. Lopez of the inadmissibility consequences of a conviction, as well as the fact of a conviction itself precluding any defenses to deportation that Mr. Lopez may have had. This court recently decided Tarrant, which recognized that there are defenses to deportation, that just because Mr. Lopez was in this country without legal immigration status, that alone did not render him automatically deportable. The fact of a state conviction can be the necessary and sufficient condition to render someone deportable, to bring someone to the attention of immigration authorities, and to preclude any defenses to deportation that Mr. Lopez had.
So putting that together, the answer to my question is, in 1999, this lawyer needed to say, you've been charged with 3 offenses. One of them, if you're convicted, will have no further deportation consequences. The other 2, if you're convicted, will, if you sometime got deported because you're undocumented and were returned, you couldn't because you were convicted of these 2 offenses?
Not exactly.
I don't mean to, but I think that this is the weakness in your argument, because now you're turning this lawyer in 1999 into a very sophisticated immigration lawyer, 11 years before Padilla was even decided.
Padilla is clearly applicable in 1999 and in February of 2000 when Mr.
What case
Lopez
says that?
went to trial.
What case says that? Do you have any case ever
That,
has gone this far back on Padilla and said what you want us to say?
yes, Padilla is applicable at least until 1998, and I can submit a 16-hour
No.
letter
Do you have
on
any
that.
case that you can cite to me?
Off the top of my...
Yeah, well, but it's important, right? Because, you know, finality is part of what we have to worry about all the time. And I know you can piece together the case law to say that you should go back in Padilla to 1996, but is there any case that's ever done what you're asking us to do?
Yes, there is, and off the top of my head, I would have to submit a 16L letter, but it is clear that Padilla was applicable in February of 2000. It is clear. And with this court's permission, I would like to spend some time addressing the second issue raised by my brief, unless the court would like to continue pursuing the issue of deficient performance and prejudice.
We would like to hear you on prejudice.
You would like to hear on prejudice. So there was a reasonable probability that but for counsel's errors, Mr. Lopez would have sought and secured a plea, and the result of that plea would have been more favorable than the outcome of a trial.
In assessing that, after you filed your briefs, Commonwealth v. Torres came out at 495 Mass 1008. Are you familiar with Torres?
I'm not, Your Honor.
maybe that could be part of a 16 letter as well. It establishes a framework. There's a reasonable person framework, not whether the defendant would have make a decision. But it's also in the context of a defendant who pled instead of went to trial. So my question is, your defendant went to trial instead of pleading. Do you believe the same framework applies?
It's a slightly different framework under Mourinho, Your Honor. Under this rubric and under this court's prejudice rubric, Mr. Lopez needs to demonstrate a reasonable probability that the prosecution would have made an offer, that Mr. Lopez would have accepted it, and that the court would have approved it. I believe all three of these criteria are met in this case. First, with respect to the first prong, a reasonable probability that the prosecution would have made an offer, we know that plea discussions occurred in this case, and the Commonwealth did not dispute that below in the trial court. Trial counsel...
But discussions aren't, it doesn't mean an offer was made.
In the trial court, the Commonwealth asserted that they have no reason to doubt that a plea offer was not made, because plea offers are made in almost every case in the district court. Trial counsel stated that he had plea discussions on at least 2 instances.
But doesn't that cut against your client, though?
No, it doesn't, Your Honor, because trial counsel was unequivocally wrong about what the immigration consequences were of a conviction, so he could not possibly have engaged in plea negotiations to safeguard Mr. Lopez's most important priority, remaining in this country.
But apart from that, is it clear that he relayed any conversations with the ADA to your client?
We don't have a record of that, Your Honor. And so there's the question is whether there's a reasonable probability that trial counsel could have secured this plea if he had been effective, if he had been correct as to what the immigration consequences are. And motion counsel attempted to prove this through an evidentiary hearing. Second,
What is this plea? What do you say? I just want to have in my head. What is it? What is the plea that you're saying counsel should have been able to accomplish? Reasonable probability is the language of the law, right?
correct. I see that I'm running low on time, so if I could refer
I have you
Your
at 5
Honor
minutes. I have you at 5 minutes. That's lots of time.
I'd refer Your Honor to pages 22 to 28 of my brief, where I outline what a reasonable plea could have been in this case. A plea that would have safeguarded Mr. Lopez's ability to remain in this country would have been very reasonable and very likely in the district court. First, he could have pled guilty outright to assault and battery, which he was acquitted of after trial. With respect to malicious destruction of property over $250,000, he could have pled to the lesser included offense that he was convicted of after trial. With respect to breaking and entering at the nighttime with intent to commit a felony, that's the only charge that trial counsel would have needed to focus on breaking down in plea negotiations.
It had to go to misdemeanor? That one has to go to a misdemeanor, right?
That one would have had to be broken down to breaking and entering.
I get it then. I know that you're concerned about your time, but you say counsel's advice was unequivocally wrong. What was unequivocally wrong about what, we don't know what counsel's advice was, we have an email from counsel, but what was unequivocally wrong about what counsel said?
Well, with respect to the assault and battery charge, as I mentioned, counsel was wrong that that would carry immigration
But it was, he gave general, he said, the advice that he indicates in that email is general advice, right? He says, basically, if you're convicted of a crime of moral turpitude or a felony, he may have said a felony over 1 year, I can't remember, then you're going to be deportable, right? It's likely you will be deported, something like that.
So I would refer Your Honor to De Jesus, which is very clear on this point, that advising a client in probabilistic terms of consequences that are mandatory and certain is deficient performance. It's analogous to advising a client who's facing a 5-year mandatory minimum that they may be sentenced up to 5 years, not that they are facing a mando on that charge. And that is
And the
deficient
case you would
performance.
rely on for why that kind of advice has to be given to an undocumented alien is what?
Would be De Jesus, Your Honor.
Is De Jesus an undocumented?
De Jesus was a non-citizen client, Your Honor.
Okay.
And Lavrinenko would be the case that is clear and unequivocal that trial counsel has a clear duty to investigate a non-citizen client's immigration status and what the immigration consequences of pleas and lesser
I'm familiar with the
included
law.
offenses would be.
What is not reflected in the briefs from either side is the fact that the law you're citing is 16 years after the advice in this case was given. And no motion was filed for 22 years after this conviction. To me, that's very difficult to swallow, very difficult to understand. I mean, we have statutes of limitations that, you know, if you file a lawsuit on a contract under seal, you have to do it within 20 years. Anyway, you want to move to your other issue.
Statute of limitations on filing a Rule 30B, as Mr. Lopez did in this case. Secondly, he had no reason to know the immigration consequences of his conviction because this case was his one and only contact with the criminal legal system of any country. At no time would he have come into contact with any other lawyer who would have corrected the deficient, ineffective advice that he was given by his trial counsel. He did not know until he attempted to adjust his status in this country as he had the right to do.
Let's talk
if
about
not
the
for this
let's talk
conviction.
about the failure to appeal issue.
Thank you.
And
Your Honor.
and I understand that we've asked a lot of questions, or I have, so you have a little more time. That's fine.
Thank you, Your Honor. With respect to the second issue raised in this appeal, the trial record was not preserved, and as a result of trial counsel's deficient performance in not filing a notice of appeal. The absence of any record of trial proceedings to review for error creates a due process problem, and where the rubber really meets the road is the question of remedy. So conceptually here, we have two different doctrines.
Your position that it's per se ineffective assistance not to have filed a notice of appeal?
Pretty much, I believe Trussell is clear on this, that there's little, if any, contest over ineffectiveness for failure to file a notice of an appeal after an unsuccessful defense at trial.
So you always have to file an appeal whether the guy's got an issue or not?
Well, here we have trial counsel who very studiously avoid saying that he advised Mr. Lopez of his right to appeal. What he says is, I considered an appeal. Never does he say that he advised Mr. Lopez of an appeal. Because there's no reasonable universe in which Mr. Lopez, had he known of the immigration consequences of his conviction, would not have requested his trial counsel to file a notice of appeal.
Is it possible that your client had just had enough? That he went through this whole process, trial, conviction, and he's done? I mean, why do we put that on the lawyer, that the lawyer should have kept the litigation going? That he may have just had it.
Had Mr. Lopez known that merely filing a notice of appeal would have stayed the drastic and draconian immigration consequences to which he was subject simply by virtue of a conviction, he would have asked his trial counsel to file this notice of appeal that could have proceeded with no involvement of him at no cost to him.
What if he was concerned that that's like raising your hand? Filing a notice of appeal is raising your hand and saying, here, I'm over here. Why don't we take a look at whether I have immigration issues too? Why couldn't that have been the concern? I'm out, I'm walking, and I don't want any more contact with the legal system because I'm an undocumented alien.
He was serving 6 months of administrative probation. He presumptively had 6 more months of contact with the legal
probation.
system.
Yeah.
With probation, right. And so merely filing the notice of appeal would have stayed those consequences. It would have protected him from any deportation and admissibility risks of a conviction.
But Counsel, is that an adequate ground for appeal? The cases you cite, Roe, for instance, they talk about a defense or an appeal of the issue before the trial. Like that he gave up like an affirmative defense, or he gave up some sort of issue at trial, not a prospective appeal for an issue that had nothing to do with the trial. Does that make sense?
I'm sorry, I'm not following.
For instance, again, you cite Roe, the SCOTUS case, and other cases for the proposition that, well, they stand for the proposition there has to be some non-frivolous defense that would be the subject of appeal. They don't have to name the issue, the defendant, often they're pro se, but there has to be some reason that there would have been an appeal. And usually the cases cite a reason that was disputed during the trial. Elements of the offense, defenses, things like of that nature. But you're citing something entirely different. You're citing something that happens after the conviction as a basis for the appeal. And I'm asking you if that's a proper basis to consider for filing an appeal.
Yes, it is. This is the dilemma we get when two doctrines butt heads. One, what happens when no notice of appeal is filed, and secondly, what happens when there's no record preserved for appeal. And so we're out of the ambit of Cowie, of Commonwealth v. Cowie, and in the ambit of Commonwealth v. Harris. And Mr. Lopez was entitled to an evidentiary hearing pursuant to Commonwealth v. Harris, at which he had an opportunity to endeavor to reconstruct the trial record sufficient to present his claims as he would on direct appeal. I submit that Mr. Lopez would have had a very good claim under Commonwealth v. Randall and Commonwealth v. Poff. Although this was a bench trial, had Judge Flatley properly instructed herself, as we assume she did, under the model jury instructions applicable at the time, there would have been instructional error. This could have been one of Mr. Lopez's appellate claims.
Instructional error on what? It's like on an
breaking
issue of knowledge or intent?
Exactly, intent to commit a felony.
On the intent to commit a felony on the breaking and entering?
Exactly, which is precisely the charge
But
that
boy,
is carrying, that is preventing.
I feel like we're in, wow. So the argument is that if we reconstruct this record, the judge would have misinstructed herself on an issue that was corrected after 1999, and therefore this person should be entitled to what?
So you say after 1999, but Randall was decided by this court only 6 months after Mr. Lopez's conviction. This was on appeal at the time of his trial. This isn't a greatly, in the future issue.
You have us assuming the judge would have made the same mistake that was made in Randall, and therefore your client's appeal should be deemed to be proper?
No. I don't have you assuming that, Your Honor. What I do have is that is part of my claim for why Lopez was entitled in the trial court to an evidentiary hearing pursuant to Commonwealth v. Harris
to
endeavor to reconstruct the record.
Right, but what's the end game?
The end game is one, to see if the record could be reconstructed so that he could appeal his conviction as he has a constitutional right to do. Secondly, if no record could be reconstructed, he has the right to a new trial, right? I believe that Mr. Lopez can win on this record, that he can win a new trial on this record, because in the trial court, the Commonwealth did not dispute that the record could not be reconstructed, and they cannot dispute that for the first time on appeal.
So then, if the record can't be reconstructed because nothing's been okay, we have your argument. We're well over time. I think it's time for us to hear from the Commonwealth.
Thank you very much.
Good morning. May it please the court, Kristen Jing for the Commonwealth.
Maybe we ought to start with the second issue.
Sure, happy to.
Is it per se ineffective assistance of counsel not to file a notice of appeal?
I would submit it's not. I don't think any of the cases cited by my sister or myself stand for that proposition.
What about not asking the client? Is it per se error to not ask the client whether the client wishes to seek an appeal?
There are no cases stating that explicitly, but yes.
It's like a fundamental right, though, doesn't it?
Yes, I think that is a fair statement. And on this
Okay,
record.
so how do we resolve that without an evidentiary hearing? How do we resolve whether counsel was ineffective in failing to file a notice of appeal, or potentially, as Judge Smyth says, failing even to discuss the issue with his client without an evidentiary hearing?
On this record, I agree with you, and I believe I stated that in my brief, that if this court is inclined to find deficient performance, I think the correct procedure would be to remand for an evidentiary hearing to hear from counsel.
I don't know if we're inclined to find deficient performance. We just don't know.
We don't know. That's correct. That's correct. But I think you don't even need to get there, because I do think there needs to be some showing of prejudice. In this case, what the defendant is claiming is because he waited 2 decades to bring up this issue, we have no record of anything. And he's getting basically a better deal, a better shot if we say just because you don't file a notice of appeal and we have no record, then you automatically get a new trial. That is
What should we do with that? I don't think either of you cited any cases that address this problem.
I agree with you. This is a very unique circumstance, but I think
It's unique now.
Yes.
Maybe it'll be unique, but if we were to say, oh, you can reopen something after 22 years by taking a look, and you know what, we don't have a record, so that helps us.
Correct.
Then that's a problem for me.
I agree it's a problem.
But, so help us a little bit. Think about that, because there may have been ineffective assistance here, but if there was ineffective assistance, what would you do about it at this point? On the issue of, we're not at Padilla yet, we're on the issue of failing to file a notice of appeal.
Sure. I think it would be a very different case if the defendant's affidavit indicated that all along I felt like this part of my trial was not fair, that this happened, that I talked to my lawyer about it, it never sat right with me, or if a certain witness comes forward and says, this happened and it was never addressed, but we have none of that here.
So you're saying the defendant needed to come forward with more, and without more, we can say, well, there might have been ineffective assistance, but you haven't shown prejudice.
There was deficient performance because counsel should discuss this with client before letting that 30 days lapse. But if there were no issues, no colorable claims that could have been brought at the time, I don't think you just automatically get a new trial. So I would agree that if there was some indication.
Alvarez suggests that you don't have to show what issues you had.
I'm sorry?
Alvarez.
Correct.
Suggests that you don't have to show what issues, that you had meritorious issues in order to get a new trial for failure to perfect an appeal.
I'm not sure it says that you don't need to show colorable issues to get a new trial. In that case, the appeal was reinstated. So in that case, it's a little bit similar to this in that no notice of appeal was filed within the 30 days, but counsel caught it and appealed to either the single justice or the appeals court for leave to file a notice of appeal late. So all this was caught much quicker. And in that case, the court was just saying, let's not send it down to the trial court and waste all this time if the same issues are going to be raised. At the end of the day, Alvarez still needed to present some sort of colorable issue, some sort of error in the trial.
It's hard to imagine that you would reverse a conviction when no one says to you what the appellate issue is.
That's the issue that I'm having. That's exactly the issue that I'm having, and there is no right to reconstruct a record to find an issue that wasn't previously identified. That just doesn't make sense to me.
How long is there why is it that there's no, well, I guess why, so the transcript in 1999 would have been taken by mouth, right?
Presumably, yes. I think back in those days you had to order a CD.
We didn't have this. So How is it that there's no record? Do we know?
There's no record, in terms of I can say from the district attorney's perspective, it was a district court case, so we're only required to keep our own file for 4 years, so that would have long ago been destroyed. I can't speak for trial counsel as to why he doesn't have any part of his file
Okay, but I'm asking you, because you're the Commonwealth.
Yes.
Do we know that there's no way to reconstruct the actual record of the trial? In other words, there would have been a court reporter there.
Yes.
They would have either been doing the, talking into the mouthpiece,
Yes.
or you're young. I remember this, or they would have been typing it in, and do we know that record doesn't exist anymore? What do we know about what effort has been made to try to find that out?
I can't speak to trying to track down the stenographer from the year 2000 to try to find the notes.
We know nothing.
Well, we did go to the police department to try to get a police report. We did, I know that the trial ADA did make efforts to try to gather as much information, at least about the crime, as she could, and was not able to come up with more than what has been presented.
Well, something also I'm curious about, even if we had a defendant who submits an affidavit and outlines all sorts of terrible things that happened or things that didn't happen at the trial that should have happened, like if the defendant, for example, just says the judge failed to instruct on reasonable doubt, what is a motion judge to do with that affidavit? I mean, are you entitled to an evidentiary hearing just because someone makes that allegation in an affidavit?
Well, I think it goes a little bit beyond that. At least we would have some idea of what we need to reconstruct. So we can see if the judge is available to speak on their memory of the trial. We can maybe try to track down the prosecutor, other people that may have been present. So here we have no idea what the potential claims would have been, at least at the stage of the trial court in this case. We just have no idea.
No, but what I mean is, can't the motion judge say, well, 25 years has gone by, I don't believe a word that's in this affidavit?
Oh, absolutely. Sure. Sure. It would be, we at least would have more to go on in terms of trying to reconstruct a record to speak to that particular issue. We could have the defendant testify. There would just be more to go on for an evidentiary hearing versus we just have nothing. And I don't know what my claims would have been because there's no transcript to kind of go through line by line and find mistakes, right? So at least if there's some sort of allegations made in the affidavit, we have something to go on to have an evidentiary hearing, have the defendant testify as to what he thought were the errors in his trial, and then the motion judge can make a determination based on that.
You want to talk about Padilla?
Sure. So in full transparency to the court, I really had a difficult time framing this, not through no fault of my sister, but this is a really unique circumstance here. I had a completely different version of the brief drafted and had to scrap it. This is my best shot at analyzing this issue. So I think what's the most difficult part of this is the defendant was never subjected to removal proceedings. In almost every case that we have, the defendant was deported, whether it was because of the case at issue or whatnot. So I think where I was struggling is the deficient performance piece is so tied to the prejudice piece. So the consequence that this defendant faced here was that he was 20 years later not able to apply for a green card because of the convictions on his record. So then we have to look back in 1999-2000, what advice should have been given. And this court has never explicitly stated that defense counsel is required to advise a client that if you're convicted of these charges, you might have an issue applying for citizenship going forward. From my estimation,
There's nothing that says that, right?
No. Not that I was able to find.
We have sort of iteratively added things that you're supposed to advise your client of, but there's none that says, 20 years from now, and you wouldn't have to say that, but in the future,
Yes.
you would be prevented from getting a green card.
Right. Again, in circumstances also that didn't exist in 1999. His mother was not a naturalized citizen, so that wasn't even.
Get it,
Right. So
get it.
that's where I struggled.
Well, there's another consequence. I mean, he's subject to deportation due to the conviction, correct?
He's subject to deportation yes. Well, he's also subject to deportation just based on his status.
He's already subject to deportation.
That's where I was struggling. So I think there are cases that recognize that. There are some, you can apply for cancellation of removal, and I think this would prevent him from, the convictions here would have prevented him from doing that, but we're not even there because he was never
The
subjected.
cancellation of removal piece
Yes,
is discretionary in the, what used to be the INS, now is something else, right? In other words, he's undocumented.
yes,
If he weren't convicted, they would remove him. They would institute deportation proceedings.
Yes.
He would say, don't deport me, my wife and children live here in the Commonwealth, and I'm a good citizen, right?
sure.
And the convictions mean that he cannot do that.
That's my understanding of the case law, and that's cited, Tarrant cites,
And was that case law extant in 1999?
there's no case analyzing
And
that.
the cases that your sister cites are from like the 1940s, which suggests to me that that was the law in 1999, but I don't know that. I mean, I can go read the cases and I can figure out, I'm just asking you in case you knew.
I don't
don't know.
know. I apologize.
Seems like we're turning we're turning defense lawyers into immigration lawyers, but we've been doing that for the last 10 years.
Right. Well, and I think we don't even need to get there in this case because the consequence that this defendant was actually facing was inability to apply for a green card. So we're not even talking about his ability to apply for one of these exceptions if he were subjected to removal proceedings, because
Well, that's
that's
a
not
good
even what
point.
happened here.
That's a good point. I mean, what's being posited as the advice that was ineffective is sort of irrelevant to the consequence that we're worried about.
Right. So the advice
What's
that
being posited is you should have told the person that you defense counsel, should have told your client that if he's convicted of what he's charged with,
yes,
there will be consequences to your ability to come back to the country, right? Isn't that what?
yes. So so it's whether he's admissible or not, or whether he's going to be
Prevented readmission.
But and so that does
That's not what
correct.
this guy's worried about.
Right. Well, being inadmissible means that you cannot apply for a green card. So sort of downstream,
I
yes.
see.
So I think that's the argument.
They fall together, yeah.
So that is the argument, but I don't know that any case has gone as far as requiring counsel to advise of going that far. So being subject to removal,
I mean, answer that question.
Yes.
Are there any cases that say that that's required?
no. Lopez goes as far as saying this is an issue, but we're not going to address it. And I cite that in my brief. So no case has said.
Lopez, the one from Justice Wentland?
Yeah, I believe so, yes. That's the 2019 case.
Lopez comes out the other way. Lopez is supportive of the Commonwealth's position.
Right, but they do say, it's another case
They
where,
flagged the issue.
yes, it flagged the issue and said we're not going to reach it. So I'm happy to,
As a representative of the Commonwealth, is there any unease in your position considering the performance of counsel that we can glean from the emails? That he refused to cooperate with appellate counsel, that he sent a police report to the Commonwealth and he claimed he didn't have one to counsel trying to advocate for his client, that he advised counsel to tell the court that counsel couldn't find him, couldn't speak to him. That's unbelievable. I mean, does your position rest on that person doing an adequate job 20 years ago, that attorney?
I don't know that we can make any any reasonable inferences based on his behavior today versus what he did 20 years ago. You know, as an officer of the court, sure, I'm troubled by that, but at the same time, we could have had an evidentiary hearing here and called him in. I don't think you even need to get, I don't think you need to get there.
That's conceding that she's entitled to relief.
Well, but you still have to reach the prejudice piece. So yes, so if this court is inclined to find that there was a problem here and she, you know, the defendant can show prejudice, I think the correct outcome would be remand for an evidentiary hearing.
Isn't there enough of a substantial issue that it was hard for the court to find it on the papers, and there were really no finding? There was just, as the Commonwealth says, I rule.
Sure, but at the same time, given the defendant's status here, as we just have been discussing, the fact that he was undocumented and that the consequence was his inability to apply for a green card, also all the other prejudice factors here, I don't think it raised a substantial issue that would require a hearing.
But all those points weren't raised in your filings below.
Correct.
So what the judge adopted below were a lot of issues that weren't even raised today.
Well, some of the prejudice arguments were raised.
Okay.
The no prejudice arguments were raised below on both issues, right?
In fairness, I don't want to misspeak, but my memory was some prejudice arguments were raised, but I could be wrong about that. So
We can affirm on any ground.
Sure.
Supported by the record. Okay, you are also over time. Do you have anything else for us? It's our fault.
All right, thank you very much.
An unusual case. Well argued on both sides. Thank you. Third case is LaSalle v. the Commonwealth, 23P 1410. Counsel for Mr. LaSalle. Is it LaSalle or LaSalle?
LaSalle. Good morning. May it please?
Krismer.
Yes, good morning. Laura Krismer for Mr. LaSalle. I thought I would start right at the outset of addressing the issue that the Commonwealth raised in their 16L letter from last week. It is accurate that Mr. LaSalle had a Section 9 trial and lost last week. I would suggest to the court that this case is basically in the same procedural posture as the McKendry case. That case, the court addressed, the SJC addressed the issues, found merit to the issues. The only difference is because of the subsequent adjudication, he would not be entitled to discharge. It would basically put him back on the list for a new trial.
What is the McKendry case, which has not been cited to us?
The McKendry, I can give you the case. The 16L letter was just last week. It's 458 Mass 257, and that's a 2010 case.
Sorry, give it to me again.
Sure. It's 458 Mass 257, and that's a 2010 case.
And it's and in that case,
It said
the
basically,
person had gone through another Section 9. He'd been deemed to be sexually dangerous. The issues raised from the prior appeal, the Supreme Judicial Court nevertheless took up.
yes, and they found merit in the arguments, which obviously is what I'm asking you to do. The difference is that he's not entitled to discharge because of the subsequent Section 9.
I mean, I assume those arguments were questions of law.
They were questions of law.
Well, your first issue is a question of fact, right? Your first question is whether or not there was sufficient evidence of a nexus.
That is, and that's kind of an interrelated issue. And if
How
you
is that? How is it going to help anybody for us to decide that there's insufficient evidence of a nexus where he's now gone through another trial and where you'd have to examine whether there was sufficient evidence of a nexus there?
I think it would help in terms of every decision that the court decides on these sufficiency arguments sort of helps both sides. I would suggest both the Commonwealth and the defense bar to sort of narrow and hone what the essential issues
Sounds
are.
like an advisory opinion to me.
It could be that as well. I think the sufficiency argument is related in terms of the big picture for the case. More importantly, I would suggest to the court that there are at least two substantive issues that are independently important. And the first has to do with the motion in limine that was raised on the risk category labels and the 10 and 20-year recidivism rates. Those are both preserved errors. I won't reiterate what the standard is for the court in considering that, but I would suggest that there were at least 3 errors that happened in this case. One is that the percentages that the experts gave detailed them as though they were particular to Mr. LaSalle, when the case law and all of the data on the static 99R is that it's a general.
Can we just back up for a second? I
Sure.
appreciate your thinking about this, which
Sure.
is appreciated. So the McKendry case, when I pick it up and read it, is going to tell me that the SJC made a decision that it was going to access questions of law, even though the case was really otherwise moot, because we're going to see that when I read this opinion, that the SJC determined, well, I can't really grant any relief because after this, the person has been subsequently found by a jury to be sexually dangerous still, right? Which is the definition of mootness. There's no relief that the court can grant.
I agree with Your Honor that it's not the kind of relief that Mr. LaSalle would like, which is the discharge. That is not the kind of relief that he's going to be eligible because of the subsequent adjudication.
What other relief could we grant?
Well, I think in terms of again, I think all individuals who are in his position have the same weight of this proceeding that is heavy and is against them. So I think the weight of the vindications, for lack of a better word, of a court, the 3 of you saying that something happened that is wrong, is not something that we should disregard. And I think it would help to channel, so to speak, future proceedings. In other words, people who are behind Mr. LaSalle that are being scheduled for trial, it will help contour sort of the landscape for these SDP proceedings.
So let me phrase, I understand that answer. Let me phrase the question slightly differently. What are the issues of law that are left?
Sure.
And I see one, which you've already raised.
Yes.
Which is the question of the admissibility of the static 99R evidence that was presented here.
Yes.
That the only one?
The second one would be the jury instructions, Your Honor. The jury instructions, and I have a very kind of off-the-cuff kind of suggestion to you for the jury instructions. I would suggest that you have your law clerks read them to you and see if you understand what the elements the jury is supposed to be deciding the case on.
I mean, unless those are capable of repetition, why do we, in other words, unless we know that that's a jury instruction that is regularly being given in the Superior Court, why would we care?
Well, I think, as the Commonwealth aptly pointed out in my initial brief, I used the word approved, which was inaccurate. It's the MCLE model instructions. I think what it would do is that there does need to be some instructions that are either by one of 2 ways. Either we say you can't do this, or you should do this other thing. And this is really more an argument that you really shouldn't do this, and here's why.
Okay.
And the main argument on that in terms of the instructions is essentially that the second element requires this link to the QE, the qualified examiner. In this case, there were 2 QEs and 1 CAB.
And you say the instructions, if we read the instructions, the big error here was that the jury was never instructed they had to find it.
They had to link it. It had to be based on, and I think in a case like this where you do have 3 experts, right, and these are lay people who are the juries, they don't really understand. I'm coming in, as I said, to the Commonwealth. This is really, I've been practicing for 25 years. This is my first SDP case, and I will tell you I was thoroughly confused by these instructions, which is why I'm suggesting to the court that you just have somebody read them to you, because it becomes immediately apparent, at least it was to me, that these instructions are so convoluted and unintelligible, and not only for, it certainly would merit for this particular Superior Court judge. This is the unified sessions. The judges circulate. It would give some guidance to them. I'm certainly sympathetic to them. I think that we've sort of thrown this at them and let them sink or swim. And so what I'm suggesting to the court is that the instructions in this particular case were erroneous.
Well, in defense of the judge, it seems to me, as I did read the instructions, and it seems to me that they're complex and somewhat difficult to follow, I think because the statute is complex and difficult to follow. So the instructions really reflect what the legislature is telling the judges the law is.
I agree with you. I was given some history of the Section 9 proceedings, and I think given the history of it and the fact that it was overturned back in 1990, but the statute wasn't really remedied, I do think that there's a legislative fix. But before, you guys do not have any authority, obviously, to do a legislative fix. I'm asking you to do a judicial fix.
What? Wait, we don't have the authority to
No,
create
you
legislation?
Although I'm sure you would love to.
From time to time.
From time to time, or otherwise you want to stay out of it. The point that I'm trying to make is that often what happens is that the judiciary sees the problem, and that allows then somebody in the legislature to say, hey, we need to fix this problem. That's happened, you know, the 2018 crime,
I understand your
et cetera.
point about that.
Yeah.
Let's go back and talk about, if you can, the static 99. Are we just talking about the categories here, or was there other evidence that you say should have been excluded? And if so, was that evidence, so it's sort of two parts. I got the fact that you don't like the categories, right?
Yep.
Well above average, right?
Yep,
Which I think replaced sort of low, medium, high risk, right?
correct.
Okay, so we don't like the categories. Is there other evidence that went in that you think should have been excluded?
Yes, the percentages. So there's two aspects.
Percentages of likelihood of
Reoffending,
recidivism,
and you know, in the way that the static 90.
applied to each category.
Yes. Well,
23.7% for above average or whatever.
what it does is they're kind of, they're two separate things. There's the risk category labels, and then there's the percentages that go by 5 years, 10 years, 15 years. So both of those things, the George case is the only case that addressed this, and it's only in a footnote for the new labels. What counsel suggested and what I suggested in my brief is that it should be subject to Daubert and Lanigan. There should be, in any other, if we were going to do an EPA proceeding and somebody came in and said, well, I can feel the air with my finger and tell how much pollution is in it, right? We would be saying, you know, let's have a Daubert challenge to that. I don't want to belittle psychology because it's a great discipline, but I do think we need to have some.
When it is a discipline.
Yeah.
So let me just make sure I'm on the same page. Because, you know, it's about me. Sorry. my colleagues may have different views, but I need to understand it too. George didn't address the inadmissibility of figures of recidivism, like likelihood of
That's
recidivism,
correct.
right? It's
It
just
was
not
just the
addressed
risk
in George.
labels, yes.
Right. So, so these numbers, so you have an expert witness, they come in, they said, I've read Hansen, and Hansen says that this is how you do a static 99R, and here are the ranges of risk for particular years, 5 years, 10 years, 20 years,
Yep.
that apply to each of these categories.
Yes.
Right?
Yes, yes, theoretically, yes. But the two things happened in this particular case is, one, that the numbers that they were given, the percentages that were given, were not consistent.
They weren't perfect, yeah.
Yeah, they were not
Two
consistent with each
witnesses
other.
that weren't so good.
Yeah, and also, and more importantly, what they suggest is that somebody's risk is going to go up over time. And all of the research suggests the opposite of that it goes down over time. So,
Well, why do they suggest the risk goes up over time? I don't understand that. They're giving the numbers. They're saying after 5 years, it's 23.7%. After 10 years, it's 30% or something. And after
yes,
20 years, it's 40%.
yes.
Why does that suggest they go up over time? Those are the risks after 20 years.
Is 45%, and the risks after 5 years is 23%.
Right.
I think the research would suggest that it's the opposite, that the risk goes
No,
down.
those numbers suggest that the risk goes down.
Okay,
Because those numbers tell me that after 5 years, it's 23%, and then you're going to add another 7 or 8% in the next 5 years, which means the risk of recidivism is going down. The numbers themselves tell me that.
I see your point. I guess I read that differently, and perhaps that's my error on that. But to me, if
But
somebody's
I think
at risk
that's a
of...
great example of what good cross-examination can do.
It is, and counsel did cross-examine on that issue. What I would suggest to the court, though, is that In this case, particularly given the other errors, the one with the instructions in particular, it just basically was so convoluted and jumbled up, is what I would suggest to the court, that it was difficult for the jury to sort of siphon out, like, what are these experts saying? The other issue that does kind of reverting back to the sufficiency argument has to do with these community access program. And I don't disagree with the Commonwealth that this was not raised certainly directly by way of a motion in limine, but what happened procedurally was that the Commonwealth's expert, CAB expert, testified about the fact that nobody had been admitted to the CAB program for over 25 years because essentially it did not exist. What I would suggest to the court is that that really goes to the essence of what a Section 9 proceeding is supposed to be about, which is about whether this individual has made sufficient progress in treatment such that they are no longer dangerous. And by not having even access for anybody, Mr. LASELLE or anybody at the Mass Treatment Center, for over 25 years, I would suggest is a due process issue. It's statutorily mandated under 123, Section 6A. It was by the Commonwealth's own expert, not available to Mr. LASELLE. He did not apply for it, and I would suggest to the court that that's irrelevant, because even if he had applied, I'm not sure there was even...
But there is a jury instruction. Part of the instruction was, as I recall, whether the treatment center did a good job or not is not for the jury to decide.
It's not relevant.
Yeah.
Right.
So,
yes, that is part of the instructions. What I'm suggesting to the court is that it's a little bit of a different issue in the sense that it goes to whether or not he even could have. Like, the essence of it is, has he made sufficient progress? That's what the jury is supposed to make. And if he's not able to even access treatment modalities that are statutorily mandated, neither he nor anybody else can meet that criteria if they're not even allowed access to that. Because the way it was, and the Commonwealth submitted as part of their reply a new policy that went into effect, my recollection is this time last year, which was, well after the trial, well after all of this. What I would suggest is that was a recognition that the CAP program needed to be executed. It needed to exist. And I see that my time is almost done, and I'll
Thank you very much. Appreciate your argument.
Good morning. Mary Murray for the Commonwealth. Joseph LASELLE has given this court no cause to disturb the jury's verdict or the judgment that entered in the Superior Court. First of all, because of the subsequent finding, his request for relief is now moot. The court can grant him no release under the SJC's 2010 decision in McIntyre, which is cited in the 16L letter. But more importantly,
so McKendry is just a case where the court wanted to reach the legal issues because they were capable of repetition?
no, I think the site that counsel was referring to is McIntyre, not McKendry. But I think that the issue in McIntyre, it was McIntyre's direct appeal from a 2002 jury verdict that he remained sexually dangerous. 7 years, of course, before the SJC decided Johnstone, in which the court said, you have to have the opinion of at least one of the two qualified examiners. So it was on direct appeal. In the interim, Mr. McIntyre had, by my recollection, 3 subsequent Section 9 trials at which qualified examiners did opine that he was sexually dangerous, so no Johnstone issue. And the court decided the direct appeal, but said we are not going to give him he's not going to be discharged because of these subsequent orders. So that was the issue. That was how McIntyre played out, but it was on his direct appeal.
It's McIntyre, yeah, I know McIntyre.
Counsel, what about the stigma issue? You know, in the civil commitment context, the court has found even if somebody's commitment is terminated, is over, they still have a right to the appeal because of the stigma being committed. I think it's a matter of GP or NRA GP. Sure. Isn't there a stigma to being found a sexually dangerous person where he may still have a right to contest that finding?
He was already found sexually dangerous in a decision that this court affirmed. That is not, the subsequent finding doesn't change that original adjudication.
Or the finding after that.
Or the subsequent findings.
Finding in 2024.
And there have been other findings that didn't lead to appeals in this court. So yes, he's had multiple adjudications of sexual dangerousness. So the so-called stigma issue, which might be appropriate to consider on an initial commitment case, which I do not handle, it may be appropriate, wouldn't change it. He's already been adjudicated sexually dangerous, as I said, in 2010 in a decision that this court subsequently affirmed on appeal. So that adjudication doesn't change, and in fact, the SJC has been quite clear that a Section 9 proceeding in McCool, they said, the court said, is not the place to challenge the validity of the original commitment, and that was an instruction that the court gave, that you can't go back and say he wasn't sexually dangerous. He conceded that he had previously been adjudicated sexually dangerous. That was not a contested element, and the judge so instructed the jury in this 2022 case that brings us here today. So that was not even an issue. It might be in a different context, but not here. So the issue, the case that the Commonwealth suggests is moot. With respect to the sufficiency of the evidence, the Commonwealth offered ample evidence. 2 qualified examiners and 5 cab psychologists all opined that the petitioner remained sexually dangerous. Their opinions were well laid out, well defined for the jury, and his very capable, very good trial counsel did not, through her cross, meaningfully undercut those opinions in any way. And the trial judge, Judge Mulligan, properly denied the motion for a directed verdict. In particular, the mental condition, the link of that mental condition to his present risk, his multiple risk factors, both static and dynamic. Dynamic are, of course, changeable factors. And with respect to the static 99R, in George, the SJC said the score, 7, is Mr. LaSelle's case, as well as the associated statistics, are admissible.
Wait, the associated statistics in George were what?
With the statistics associated with your score.
Likelihood of recidivism?
Right. And it's important to recognize what we're talking about here.
Yeah, but the fact that the court said that that those statistics associated with those categories were admissible, that doesn't mean that there shouldn't be a Daubert hearing if one is requested with respect to the new numbers, does it? Does the judge even have discretion to deny a Daubert hearing? Somebody comes along and says, I don't think this is based in science.
Yes, a judge can deny an evidentiary hearing, but the Commonwealth would welcome one if we ever have one. The Commonwealth would welcome it. But the court was provided with the static 99R evaluator's workbook and was provided, which identified the research on which it was based. And that was all laid out in the Commonwealth's opposition to the motion to exclude. So
The court was provided, but not the jury.
well, the jury was, the petitioner's counsel did cross-examine on the statistics, cross-examined on the static 99R, cross-examined on other statistics.
But the Daubert is the judge as a gatekeeper for whether or not, it's reliable and methodologically correct.
Then we could look at what this court has said on multiple occasions, which in the...
George there was no Daubert with respect to the information in George, as I recall. The court was just presented with this should not have gone in and this should not have gone in. And the court said, well, this was fine, the numbers were fine, but,
right.
But we think the categories were no good, right?
Well, the SJC said that the prior categories didn't tell us anything of significance. But the new, and they specifically pointed out in George that the new categories were designed to address the problems with the old categories.
Because they're related to an average.
Because they're related to mathematical concepts. So average, in this case, a score of 7, individuals who score 7 are 3 to 4 times more likely than the average sex offender to reoffend.
According to research that they wanted to challenge. They said, give us a Daubert hearing. The judge said no. That was wrong, wasn't it?
No.
Really, the judge has, so if somebody in a tort case comes along and says, I think that this person's cancer was caused by too much oxygen in the air, and the defendant gets up and says, Judge, you need to have a Daubert hearing on whether that is good science. The judge has the discretion to deny it?
That's a different question than what we have
No,
here.
it's not. I don't think so. Why is it different?
The SJC has already said that the static 99R is admissible. The SJC has already said that the score and the statistics are admissible. And this court has
Which case,
repeated-
in George?
In George. And back in the old days, 20 years ago, there was a Lanigan hearing on the static 99R. I know because static 99, the prior version. And it was excluded because at that point it was not deemed to be, by Judge Gorbeau, to be deemed reliable at that time. Subsequent research came out. The Commonwealth stopped objecting to it. It came in, and in George, the SJC...
Not sure you're making the argument you think you are.
Yeah, well-
It sounds to me like there should be a Daubert hearing on the new data. Isn't it the most powerful data that the jury hears? This
Not even-
person has a 23.7% chance of recidivating in the next 5 years.
No, because what
Based
it's
on our
measuring
research.
is getting caught, charged or convicted. And the only thing that the jury needed to know about Mr. LaSalle's recidivism risk was that it's 100%, which is what I argued to the jury in the closing, because every time he's been released, he has actually reoffended. We don't...
Try this case.
I did.
Did you try the 24 case?
Yes, I did. I made the same argument.
But my memory is that in Lanigan, the SJC dealt with this and said something to the effect that you don't have to reinvent the wheel with scientific evidence at every turn. So, for example, if fingerprint testimony has been accepted in the past, it can be accepted in the future. You don't have to have a hearing on that. And I think the same holds true with, correct me if I'm wrong, but if DNA statistics change all the time, that doesn't require a Daubert hearing every time there's a change and it's 1 in 3 trillion or 1 in 10 trillion. It doesn't have to be done all over again, right?
I agree, and I think a trial judge would be hard-pressed to exclude the static 99R score and statistics after the George case.
Was the George case the result of a Daubert hearing?
I don't believe that there was one in George. I don't know that one was requested. That was an initial commitment case, so our office didn't handle that case. I don't know that one was requested, but this court has said in several cases, including in which I think, Justice Inglater, you have been a member of the panel, that the admission of the risk categories is not prejudicial, as in George, which the SJC said in George did not lead to reversal, because none of the experts relied exclusively on the static 99R. Same here. The limitations of the static 99R were explained to the jury in great detail, both on direct and on cross. And the static 99R is a limited tool. It tells us how many people how many men, adult male sex offenders, who've been charged or convicted of a sex offense in the past with a certain score are charged with a new sex offense or convicted of a new sex offense at various time gates. That's what it tells us. Nobody relies on those numbers exclusively. And it's important here to remember what Mr. LaSalle told, what the jury heard about Mr. LaSalle's own assessment of his risk, which is that he put himself at a 5 out of 10 when asked by one of the qualified examiners. He put himself far above those numbers at the present time. And those numbers tell us...
The difference between those cases, which of course I am familiar with, and which are all Rule 23s, right? Mm-hmm. The difference there is I don't recall someone saying, we need a Daubert hearing, and having the Daubert hearing denied. That's the issue that's got me worried. And although, of course, Judge Hodgens is absolutely correct, you don't need a Daubert hearing every time that ballistics science changes or every time that DNA science changes. If you have something that is new and that previously has been said by the court not to be admissible, boy, I'll tell you, the limits of the judge's discretion there are limits on the judge's discretion, at least in my view.
Even if that were the case, a point the Commonwealth does not concede, then the question is was there prejudice? And the answer to that is no, for all the reasons in George and all the reasons that have been articulated. But the statistics come in under George. That's very clear that they come in under George. And the longer you follow sex offenders, the more you detect recidivism. And it's documented in the Commonwealth's filing below, and in the brief, that you're looking here at a lifetime estimate, a lifetime risk, because the SDP statute doesn't contain any temporal limitation about when the future sexual offense must occur. The legislature could have done it that way, but they did not. So these are all relevant, as Mr. LaSelle's own history shows us. He was first arrested for a sex offense in 1988, and he wasn't arrested again for another sex offense until 1996. So if you had only looked at 5 years, you would have said, hey, he's a non-recidivist. But of course, then he reoffends in 96, 99, 2001, 2004, and 2005. And you would not have had all of that data. So you need to look at the entire lifetime. Now, with respect to the community access program, there's no due process right to a community access program. Healy against Spencer, 765 F. 3rd, 65, page 79, August 26th, 2014. The First Circuit Court of Appeals affirming a federal district court, actually Chief Judge Saras at the time, her opinion. But this is not the place to litigate that question. And the SJC has made that clear time and time again. It's not clear how a trial judge could avoid that decision, and it's not clear how this court can invite or overrule or disregard.
He never asked.
Well, and not only that, but the evidence clearly showed in the CAB report, and then when counsel decided to bring it up at trial, that he's not suitable for it. His entire treatment team and the 5 CAB psychologists said, A, he's not ready, B, these are the things that he should do. The CAB wrote out in its report, these are the things he should do before applying, and then work with his treatment team if he wants to. And that policy that I cited in the brief was only the most recent iteration. There's case law going back to the community access program and the procedures for admission going back to the 90s, and I would invite the court's attention to King versus Greenblatt, 53 F. Sub 2nd, 117, which is a June 1999 decision.
Is it accurate that no one has ever been put in that program?
It's not accurate that no one's been put in it. It's accurate that no one's been in it. But, of course, if there were going to be a legal challenge to this, there's nobody been in it since 1998. However, you would need a record to say this is a constitutional problem about why. And there's
just
no
asking
record.
a question. I don't know if it troubles your folks, but it seems odd that you would have a program and it hasn't been used for 26 years. In
Well,
any event-
I would invite the court's attention to the fact that do people apply? Or do their lawyers tell them not to apply? Because if you don't apply, then you can't be rejected. Or, and I would invite this point, which is people pursue parallel tracks, which is they're looking to get out unequivocally on a Section 9, and if they're that advanced in treatment that they're suitable for the community access program, chances are they're going to get out on the Section 9.
Okay. Time's up. Thank you both for your arguments. Thank you very much. We're going to take our mid-morning break, and we'll be back to do the last 3 cases in about no more than 15 minutes, maybe less. I think it's still morning. The fourth case on the list is Klein et al. Against Universal Property Management, 22P 160. And I think we're going to hear from the counsel for Ms. Klein and others. Benjamin Timon, is that right? Mr.
Good morning, members of the panel. Benjamin Timon for the plaintiff appellants Sarah Klein, Lauren Dobish, and Paul Rutherford. Your Honors, in allowing the defendant's motion for summary judgment below, the Superior Court either misapprehended or misapplied decades of Chapter 48 jurisprudence governing how the standing of a 40A abutter is determined, and to determine whether or not that abutter is a so-called person aggrieved under the statute. The court committed errors of law by misapplying that standing test, and at summary judgment, it ignored clearly material and contested expert testimony from two different traffic engineers that in and of itself should have precluded summary judgment. Because of those errors of law, the court should reverse and remand that decision back to the Superior Court for a trial. Now, Your Honors, the Framingham Planning Board issued special permits and other approvals allowing...
What's the error of law?
Well, the first error of law, Your Honor, is that the judge put the burden of proving their aggrievement initially on the abutters.
I mean, if you're talking about the way it was written, right?
I'm sorry?
Talking about the way the opinion was written.
Well, not just how it was written, Your Honor, but the fact that it never acknowledged that the plaintiffs held a presumption, a rebuttable presumption, but a presumption of standing as abutters, as persons of interest. Ms. Dobish...
That was discussed in oral argument, though, correct?
That was discussed in oral argument, Your Honor. It was. That's true. But my brother, I believe, cites to a Third Circuit case from the 60s that says, well, if it was in the briefing and it was argued, then we're going to assume that the judge took that into account. There's no evidence. I mean, in reading that decision, not only did the court fail to acknowledge that the burden did not initially rest upon my clients to show their standing, but she compounded that error, the court compounded that error by not identifying any evidence in the decision countervailing from the defendants that would cause that presumption of standing to proceed.
Well, now wait a second. Now, okay. So it's a rebuttable presumption, right?
It's a rebuttable presumption,
and it's
yes.
rebuttable by the evidence that comes from the defense, right?
That's correct.
And the defense says, look, the evidence here is that people are aware that there could be a traffic issue if people make a right-hand turn on Curve Street. And so they've adjusted the exit so that the car is directed to go toward Route 9. They're putting curbing there so that it's kind of hard to get around. And that was all done at the level of the board so that people were aware of that before your client sued, right?
That was right.
Although some of your clients weren't aware of it because they hadn't read anything.
Well, Ms. Klein, who's here today, not only did she read things, she attended and spoke.
That's why I said some of your clients.
The others had just bought the house a few months before. But the problem, Your Honor, with trying to assert that the court should have upheld those traffic restrictions or those mitigation measures at the exit are the following. There was evidence that remains undisputed in the record. Number one, that vehicles exiting Curve Street and making a right-hand turn will put the car on the other side of the road of Curve Street, which is a narrow residential street, and cause traffic accidents. That's page 21 of my brief.
It's undisputed that they'll cause traffic accidents? I didn't read that.
The 30B6 witness, Mr. Hasiotis, of the developer, at Record Appendix 195 through 199, testified, while he thought it was impossible that such a turn could be made, he acknowledged that if a turn was made, that the car would have to go into the other lane of traffic while making that turn.
No, he didn't acknowledge that it would cause traffic accidents, I assume.
No, in his testimony, Your Honor, he says, yes, if they can do that, it's going to raise the risk of traffic accidents, which makes perfect sense because the car's going to be on the other side of the road.
Yeah, but it's a residential street that has little traffic on it, right?
Well, it does now, but this is a car wash and coffee shop drive-through. It's drive-through only, and so the traffic is going to increase considerably. So that's fact number one that was in front of the Superior Court. Fact number two, all of the drive-through coffee shop customers will exit from that Curb Street exit. In my reply brief, I point out where the city...
Why is that? It looks to me like Wheeler Street is just as good a place to exit as Curb Street.
It may be, but the developer's own traffic report, as I...
Yeah, I saw that in your reply brief, but why? Why? I mean, they're both running parallel to one side or the other side of the development. Why is... I mean, does the traffic expert of the defendants explain why he doesn't think anybody will take Wheeler Street?
No, but that was their projection that there'd be zero people taking Wheeler.
I think it's zero who are customers of one of the two.
Of the coffee shop, that's right.
Okay.
And so if you look at the plans, the roadway is such, Your Honor, where the coffee shop traffic would be getting its coffee and be on that side of, would be on that side of the site. And so perhaps that's why the developers...
I see. When you come in, so it's this very odd sort of entrance to the car wash, right, where you have to do a big U-turn?
Yes, it is a bit of a convoluted...
But do you get out at the other... All right. In neither brief was there a full layout of the entire site, so it was a little bit hard to piece together.
But both on the fact that if cars make that right turn, and that all cars using the coffee shop, according to their expert, will use that exit, at the very least, those were disputed facts of experts at summary judgment. The third such disputed fact was...
Material?
I beg your pardon?
How material is it? So, I mean, part of what is troubling me, just to put my cards on the table a little bit, is even if there's a standing, even if your clients have standing, doesn't the board have the discretion in considering all the information before them to conclude that this use is appropriate for the district that's set up for exactly this kind of use with accommodations to try to get all traffic to go out to Route 9?
But they're not afforded that discretion, Your Honor, under clear 40A jurisprudence. It's a de novo review at the trial court level. And the trial court engaged in no fact-finding whatsoever.
It's not de novo review with respect to the decision-making of the board.
No, it is.
It's de novo review with respect to the fact-finding.
Well, correct, but the way that the test works...
That's why I asked the question, are these facts all that material?
Well, they are, because first of all, the court didn't engage in de novo review, which it's required to do. The second part of the test is once the court...
Didn't engage in de novo fact-finding, counsel, which it's not required to do if the evidence in front of it on summary judgment is such that it can grant judgment as a matter of law. Assuming all the facts, as far take Havartarian's affidavit, assume everything in it is true. Some people are not going to make a left; they're going to make a right.
Right.
And then say, still, it's within the board's. This is assuming those facts. It was within the board's discretion to grant the permit.
Well,
Did the judge do that?
Not if the judge looks at, as she should, the aggrievement that's being alleged. And so there was also evidence in the record about how each of my clients walks on that same corner. There was evidence in the record regarding the trespass, the 273 square feet of Curve Street that a survey showed is actually on the Dobish-Rutherford property.
You know, you said that and then you did nothing further with it, so I had a lot of trouble understanding why we care about that.
Well, because the Harvard Square Defenders case says that a person aggrieved is one that can bring forward a plausible...
You're still arguing standing, and I've kind of gone
past
past it.
standing.
But I mean, even on the standing issue, okay, so apparently someone agrees. Does everybody agree that there's currently a piece of Curve Street that runs over your client's property? Is that what we have?
I mean, I don't know that the other side has conceded that, but they haven't submitted
But how do we
anything
know
to
that there's
contest it.
not a prescriptive easement because it hasn't been done for the last 100 years that way?
Well, right. I mean, that's not something that the other side argued.
No, but you're the plaintiff with the burden of proof. So you say, look, this is running over our property, and then nothing more. How have you carried your burden of proof that that's an issue?
Well, because, I mean, I know you're putting it into the bucket of standing, but an aggrieved person is one that can bring forward a plausible private right or property right or legal interest. And so trespass is about as, you know...
Yeah, that'd be an agreement. I agree. I don't know that you've made your case on that. By saying, look, this will go over a piece of our property without anything further from anyone as to whether that's been going on for 100 years, or to be more accurate, 20 years and a day, why do we care?
It's something that was just discovered by a survey during the proceedings. But again, Your Honor, there's testimony in the record by the plaintiff appellants themselves that they walk that very corner that the traffic expert has said does not have sufficient mitigation. That's
And there are no sidewalks on either side of the road, right?
that's right at that area.
Do they call for sidewalks to be put in on the
northern portion.
On the northern
The planning
portion?
board called for the expansion of the width of Curve Street with sidewalks only on that portion under the incorrect assumption that as Mr. Hasiotis incorrectly said in his testimony, the defendant's 30B6 witness, that it would be impossible for a car to take a right. And, you know, it's a record appendix, pages 83, 86, and 87, is our traffic expert's testimony and Ranger Engineering that did the turning analysis, that's incorrect, that it is possible for a car to make that turn and to not damage itself. So specifically on page 83 of the record appendix, our expert said, based on the turning plans prepared by Ranger Engineering Group, which utilized the applicant's approved site plan, a vehicle as large as a very large passenger car or most SUVs will be able to negotiate the right-hand turn out of the car wash coffee shop establishment to Curve Street without striking, curbing, or otherwise damaging the vehicle or being required to execute a three-point
Which leads
turn.
me back to the question I asked before. I mean, you know, let's assume all those facts are true. Some cars are going to go, they're going to make a right turn. Even though they're not supposed to make a right turn, they're going to make a right turn. They're told they can't make a right turn, right?
Right.
They're going to make it. Is that enough to
Yes,
overturn?
it is. Because if it happens once, Your Honor, there's going to be an accident. Because, again, the evidence is clear that a car doing that is going to enter the other lane of travel. The evidence shows that approximately 60 feet south of there is the curve in Curve Street. And so, of course, if a car is coming the other direction, there's going to be a crash. And there's going to be pedestrians, including my clients, who walk that same curve,
What's
the curve where...
What's the speed limit on Curve Street?
I don't know, Your Honor.
20 miles an hour? 25? Something like that, right?
It's probably 25, but I don't know the answer to that, Your Honor. But, it wouldn't have to happen very many times.
Aren't these the kinds of things that the board can take into consideration in its discretion in determining whether it's appropriate to grant a permit so that people can build this right on Route 9 in a business district?
Well, they can, but they didn't have the benefit of our traffic expertise, which the court should have considered, instead of ignored it in its decision, in de novo review. This decision does not indicate to your honors in any way whether the Superior Court judge even considered our traffic testimony. And you've read in the brief the back and forth regarding the motion to strike, and I think it's a very fair supposition that the judge who decided summary judgment, who was a different judge than the one who denied my brother's motion to strike, effectively struck it herself. I mean, it came up in oral argument, whether there was, all kinds of back and forth on the untimeliness of it, but then Judge Rooney, a different judge than the judge who decided this, Judge Farzan, denied the motion to strike. And it's a very fair inference to make that the second judge, the summary judgment judge, effectively struck this evidence, which...
Well, she didn't address it in her opinion.
She didn't address it in her
Okay.
opinion.
We have your argument.
Thank you.
Good morning, Your Honors. May it please the Court, Bridget Bradley on behalf of the City of Framingham Planning Board.
Are you folks splitting your time?
We are. I have 5 minutes, so
And
Attorney Kelly has 10 minutes.
10 minutes?
Yes. So I'll make this as brief as I can. I think Your Honors understand the Board's role here, and what the Board did was take into consideration all of the facts in allowing the
who filed the motion for summary judgment? Did the board file that, or was that filed by?
We each filed a separate one, and initially, the judge allowed, and I don't know why, mine first, and then subsequently allowed the one for UPM.
Did you make an argument in your motion for summary judgment that even if there was standing, the court can decide as a matter of law that the decision, assuming all the facts that the plaintiffs say are true, the court can still make the determination as a matter of law that it was an acceptable grant of a special permit?
I think we made both arguments, that they lacked standing, and as the court found, they addressed both. She found that they did not have standing.
There's a paragraph that can be read either way, but then she ends it with standing, so it looks like it's about standing.
I think she ends it with that they don't have standing and that there were not material facts.
Did I misread that?
In dispute. That the appellants lacked any credible evidence to support their claim that the board acted arbitrarily. So I think she handled both of those.
That's important. Hold on. Let me just see what you're referring to there.
I think it's on page 5. The plaintiffs do not have standing to appeal and lack any evidence to support a claim that the board acted in an arbitrary and capricious manner. Summary judgment must enter for the board. And she addresses it in the paragraph
Okay.
before as well.
Thank you. That's helpful.
So I think it's clear, Your Honors, that what we have here is a business on Route 9 in Framingham, which is the thoroughfare through the city of Framingham. It is zoned as a business zone, which allows, according to the zoning, automotive-oriented commercial development in areas already predominantly built in this manner. And that's expressly what we have here. This large lot sits on Route 9. On the other corner of Curve Street on Route 9 is a restaurant. Behind that is a barber shop, and all other.
Has this been built yet, or has it been sitting there?
It has been sitting there.
Okay, so the lot is still vacant, and when was the application filed? The permit was granted when? A couple years ago?
I believe in 2021, so we're going on 4 years now. And it has been sitting vacant since that time.
And the reason for that is because you build at your own risk as long as it's on appeal, right?
Correct. I believe, and Attorney Kelly
Does Framingham have a 2021 decision by the board? Does the town have a policy that they won't grant building permits as long as the appeal is pending?
No, not that I know of.
So they could build at their own risk if they wanted to.
They could, and Attorney Kelly could address this more. I think they are under agreement to buy the piece of property, so I think that it's all contingent upon this happening. But I think it's clear, Your Honor, that there are no material facts in dispute, that even if a couple of cars, which we don't know how many they are because the expert...
Your brief isn't the one that says we vehemently dispute that anyone's going to make that right turn?
I don't think that that was mine.
Not your brief?
But even if they could, I don't think that that rises to the level of a material fact in dispute. If somebody wants to take a right-hand turn, go against the do not turn right, that is a motor vehicle issue, not a zoning issue.
Why won't they use Wheeler?
I think that they could use Wheeler, and I think, Judge, that...
So who hired the expert who said nobody's going to use Wheeler?
I think UPM expert, because of the way that the traffic is, Judge. But I think here...
Well, the way the traffic is that people are going to be motivated to go the other direction to get to that circle and drive into the center of Framingham. Some of those customers are going to be motivated to do that. All right, your time is up. Why don't we hear from your opponent? Your co-counsel.
Morning, Your Honors. If
Morning.
please the court, Michael Kelly for the private defendants. And since I only have 10 minutes, I will take your advice and cut to the chase, if I may. The issue of the rebuttable presumption was argued ad nauseum in the briefs and at the oral argument. The case of Standerwick, which we have cited in our brief, which is a 2006 Supreme Judicial Court decision, is right on point here. The defendant developer filed a motion for summary judgment, which in support of filed all of the expert reports and other information and documents that were presented to the board. And the court found in that case that the filing of those documents and in support of the motion for summary judgment, just like any other motion for summary judgment, they're included in the record. And that those the reports filed in support of the motion for summary judgment rebutted the presumption of standing.
So how did you rebut the presumption of standing here? With respect to traffic, all the others, I think, have sort of fallen away in the briefs. I mean, at least that to my eye. But traffic, you've got somebody who literally lives next door on a street that's a clear residential street that has two 90-degree turns in it. And they say, hey, I walk up and down that street. It has 24 feet wide. It has no sidewalks. And cars are going to make that right turn because they're going to want to go out, it's not very far, to Union Street. How have you rebutted the presumption that they are a person aggrieved?
The judge below pointed that out very quickly. Ms. Bradley was discussing the issue of a right turn. She said, does that go into a neighborhood or just by the plaintiffs? It goes by a neighborhood, goes through a neighborhood. There's 6 or 8 houses. There's businesses right at the corner that they're complaining about.
So that's the argument that they have to have a particularized harm.
That's correct, Your Honor.
Why is that good law?
Pardon me?
I mean, I haven't read a case that really turned on the particularized harm thing that made a whole lot of sense to me. I mean, so because they have other people who are harmed equally, the other 6 houses on that street, they are no longer a person aggrieved who can raise this problem?
As the court rightfully found, the harm has to be particularized to those plaintiffs.
But
and if
why?
The harm is suffered,
why does that make any sense?
That's the law, Your Honor. That's been the law for many, many years here as well.
I'm not so sure, counsel. I didn't read too many cases. I read no case like this. No case where someone who has a harm that they identify because they live next door to the development is told, you can't raise this because there are another 6 houses in the neighborhood that could raise the same thing, and so therefore you don't have a particularized harm. There's no case that says that.
No, there isn't. That there is, the cases are uniform in that it's got to be particular to that individual who's taking the appeal. And the other residents, whatever, if there's a harm, and I would suggesting that there's a harm because some cars may violate the law, go through a signage illegally, and go over a curbing to go up Curve Street is speculative at best. And the other...
It was your brief that said you vehemently disagree.
Yes, yes. I won't get into the, I could get into all the details of the traffic expert, but his testimony's been rejected in every case that's reported where he's testified. He did no traffic study. He didn't even visit the site. And
right, but we can't make a determination. So part of the problem here is that the decision was made on summary judgment. The 2 cases that I found most useful, the Kenner case and the more recent decision from on Town of Sherburne from the Supreme Judicial Court, are both cases after trial, right? I mean, you can argue at trial, you can dauber it, but none of that happened because the judge decided this on summary judgment because that was what was filed, and ignored the fact that they had an expert on traffic.
It was mentioned many, many times, and I believe the reason it wasn't specifically mentioned because she asked that question, does it go through a neighborhood? And if it did, and that everyone else in the neighborhood the traffic would go by their house. And also said on multiple occasions that the evidence they presented was speculative. This traffic engineer says, I think it's probable some, that's what his wording is, it's probable some cars will take an illegal turn. He doesn't say how many.
Yes, let me ask you this, though.
Anything else.
Let me ask you this.
If you said it was 50, that's one thing.
Counsel.
But if it's 2.
Counsel, let me ask you this.
Yes, sir.
Do you always need an expert to rebut something that another expert is saying? So in other words, if you just have residents who come into a planning board meeting and they explain what they can see with their own eyes, the conditions of their own neighborhood, and so forth, the traffic conditions, is that not enough to withstand summary judgment, or do they actually have to go out and hire an expert to say the very same things?
The cases are legion that in regard to traffic issues, expert testimony is required. They can testify to their observations, but they can't testify as to what's going to happen if there's some additional cars that come on this road. That's certainly not within their scope. But they can testify, this is what I see and this is what I experience.
In order to oppose somebody who's building next door to me, I got to hire an expert to say the following. Even if you tell people they're supposed to turn left, if they really want to turn right, they're going to turn right.
Once again, that's extremely speculative. It has no evidentiary basis. If I say that I might walk out the courthouse door today and I might get hit by a car, that's basically what this so-called expert is saying, is that there may be some, he doesn't give a number. So if there's 1, is that a harm? If there's 2, is that a harm? If he had given a number that in his opinion...
Well, the problem is, in counsel, the problem is putting it in terms of harm.
Pardon me?
The problem is putting it in terms of harm. If this decision is right on the issue of standing, there is no difference between standing and the merits.
Well, that's
and I mean, I've read the cases, but I struggle with that. We're trying to figure out whether this person has been aggrieved first. And then we're trying to figure out whether, if they have been aggrieved, they've made a case that the board erred. Separate issue, which I understand from your colleague was briefed and decided by the judge. But as to whether they're aggrieved, I mean, if they're not aggrieved, there's no difference between standing and the merits, is there?
No, not, well, in this case, there is, because they haven't shown a special agreement. The rest of the neighbors will get the same traffic. And once again, Your Honor, it's purely speculative on the part of this expert saying there may be cars. It's probable some cars may take a right. That's not an opinion to the best of his engineering and scientific standards.
Because it's predictive. So what should it have said? I know from studying other places where people similarly have been told not to make a right turn, that this is how many cars are going to make a right turn?
That's exactly right, Your Honor. And that's what traffic engineers do when they do traffic studies. This expert did no traffic study whatsoever. He didn't even know how many cars are on Curve Street. He didn't opine to any of that. And the cars all come in,
It's not a
go
question of
in
how
one.
many are on Curve Street now. It's a question of how many are going to be on Curve Street once your development is there and people are getting their coffee and their car washed.
And nobody knows. It's pure guess, a pure guess. There are studies. He could have tried to come up with a study of how many cars go illegally violate traffic signals, traffic signage, and directional curbing at sites like this. He did nothing. He didn't present any evidence to support his speculation and guess that some cars will go right. There's no basis for his testimony.
I suppose. I mean, that's really an argument that as a matter of law, read his affidavit. His affidavit as a matter of law fails Daubert, basically.
Yep.
Fails Lanigan.
I
don't know of cases that have done that.
It shows that there's no special agreement because it hasn't been shown by his affidavit.
Okay. I think we have your arguments, folks. We appreciate
Thank
it.
you.
Understand the issues. Thanks very much.
Thank you.
Fifth case is Klein v. Klein, 24P 159, and I think we hear first from Mr. Clark. Is that right?
Thank you, Your Honor. Good afternoon.
Might be afternoon by now. Yeah.
I believe it is. If it pleases the court, as much as it pains me to say it, we have been here before on this matter, and unfortunately, the trial court's resolution on remand really failed to clarify really any issues. I think here we've got a strange mashup of contract principles and, contempt principles, which, as I noted in, by way of a post-judgment motion, really was not clarified by the court. She simply made two references to two paragraphs stating that, or referring to my client's apparent breach of the parties' agreement. Now we have a second question about the proper treatment of a merging provision.
What do you think the error was that was made?
I'm sorry, Your Honor?
What's the error that you're complaining of?
I think that the biggest error the trial court made was failing to characterize what exactly she was adjudicating. This obviously came from a judgment of contempt, and we would expect that, since the allegation was that there was a violation of the judgment as it related to alimony, that the remand judgment should have also determined whether my client was in contempt. And she failed to do that.
Well, that's a separate issue. I mean, your first complaint is my client has been ordered to pay alimony for what turns out to be a relatively short period of time, right? Because once he retired, I think, then the judge stopped the alimony, right?
Actually, she did not stop the alimony until he subsequently filed a complaint for modification. This was filed after the contempt
That was on the
proceedings
basis of his retirement.
Yes, it was.
Okay, and so the period we're talking about is like a year and a half or something like that? Between the time that he
Correct.
reached age 66, which would have entitled him under the Alimony Reform Act, 49F, to stop having to pay alimony, and the time that the judge actually said he no longer has to pay alimony. So that, am I right about that?
Somewhat. He actually continued to pay alimony until he reached age 70 and actually had begun receiving maximum Social Security benefits.
But am I right that the time period that we're talking about is about 18 months?
That's correct, Your Honor.
Okay. And that the judge ultimately made the decision he no longer has to pay alimony because he had retired?
Yes, but based on a separate complaint.
I understand that. I understand that.
Well, I think the overarching question.
So what we're saying is, you're saying the mistake here is not following 49F, but instead reaching the conclusion that the judgment required him to continue to pay.
Yes.
Okay. And you're saying, as I understand it, the judge's error was in failing to recognize that this was a judgment and not a contract.
In part, that's correct, Your Honor.
What else?
Well, I think that, I think one glaring error, again, is that, she failed to characterize the nature of her judgment and, whether it was a contempt judgment or it seems based on.
Why does that matter?
Well, it matters, again, going back to your previous question, it matters because the status of a merging provision of a separation agreement is not that of a contract. Rather, it is.
Okay, that was my first part. That was
judgment.
Yeah. So the error that you're complaining of is, in your view, the order of the judge on remand treated the prior judgment as a contract, looked at the extrinsic evidence, credited it, and determined that the parties had agreed that the payment would extend beyond the 49F period.
Yes, and.
But have you read Kavanaugh against Kavanaugh, which says, this is the Supreme Court, less than 2 years ago, where the party separation agreement was merged into the judgment of divorce, it retains no independent legal significance apart from the judgment. However, because a separation agreement is a contract, to the extent that a judgment incorporates the term of a separation agreement, we may apply contract principles to the interpretation of the judgment.
Okay.
That's the law.
And, well, I think the problem here is that the trial judge.
Isn't that what happened here? I mean, you're
Possibly.
criticizing our court for suggesting that parole evidence should be taken. The law is that parole evidence should be taken. They took the parole evidence. It turns out the parole evidence is pretty darn good because somebody told the judge, when the judge got up there to enter the judgment, that they were going to do this a little differently and not have a durational term. Right? That was pretty good parole evidence.
Well, bear in mind that this was December of 2012, and at that time we still really lacked a significant amount of guidance that we've received since that time regarding the proper application of the alimony reform statute. And in this case, particularly the context of a contempt standard, and here is where the judge's reference to Sachs v. Sachs, and I believe in paragraphs 81 and 82 is relevant. The reason why we have a standard of clear and convincing evidence pursuant to Burchell, but the requirement of a clear and an unequivocal order.
She didn't find contempt, counsel. She shouldn't have found contempt because our court told her that there wasn't enough evidence to find contempt. But that doesn't matter. You still have to construe the order.
Well, even if the order were properly construed that way, it was not at all clear that that is how a court would eventually construe it, which at least.
I don't understand. I really don't understand. I mean, So if you're familiar, I wrote a case called Smyth against Smyth that made the distinction between contempt and the fact that you still have to construe the order. I didn't make up that law. It came from another case called Wooters against Wooters. I mean, so contempt is out the door. It may affect whether or not she should have entered judgment for fees.
Correct, and that's the point I was about to make.
Doesn't affect the fact that she has to construe the order, right?
Well, I guess there's sort of an overarching question here as to whether an agreement which is otherwise silent as to the application of the Alimony Reform Act and the durational limits in particular, whether in that case where an agreement is silent, whether the parties to that agreement should reasonably expect the provisions of the statute to apply.
Well, that goes to the construction of the judge's order where the Alimony Reform Act applied, right? And the judge takes the evidence of what was said, the new judge. Is it the same judge? It's a different judge, right? The judge on remand from this court was a different judge than the judge who'd entered judgment.
Same judge, Your Honor.
Same judge.
Yes.
Same judge, and she reads what was said to her. She came on the bench, and the first question was, what's the duration? And I think you stood up and said, we've deliberately not put a duration in there because the wife has a disability.
And well, I won't speculate as for my motive at the time because, to be perfectly honest, I had no recollection at the time counsel was able to come up with the transcript of that colloquy. And although I suspect that it was a 9:30 a.m. call, simply to approve an agreement which we had already created.
Right, but which the judge was concerned about because there was no duration as to alimony.
But the judge also made no finding.
At that time, was she
judgment.
required to? Well, now wait a second. She's required to by the statute, right? But why can't what she said in response to what you said, so you spoke, and then counsel for the wife spoke, seemed to be in agreement. There was no duration that was set at this point, and she says, okay. Why isn't that a finding satisfactory for purposes of 49F, that we're not following the provisions of the Alimony Reform Act in this instance?
Well, the statute refers to written findings. And in this case, nine years after the fact,
you don't think it's satisfactory to be a written finding to have something said on the record?
Well,
I mean, there are a whole lot of other contexts where we accept things that are said on the record as written findings.
It depends on whether the record is preserved and under current rules. I mean, obviously, the technology has improved substantially.
Were you here for the second case today?
Unfortunately, I got here for the third.
No, we had a similar problem where we were trying to figure out what to do with a case where we didn't have findings. But here we do. We have the transcript.
Okay, unexpectedly. And it was not, well, at the time of the judgment, the parties were not provided with a copy of the transcript. And because we had just entered a judgment, we did not seek one. So I guess the question again is whether parties can reasonably expect the statute to apply and the statute to mean what it says. And if not, and if this court decides that it was correct for the trial judge to consider parole evidence, and again, I did have some question about that because the context in which that remand was issued, first the panel did not express any opinion as to the merits of accepting parole evidence, and also the court in that case relied on McManus, which referred to a surviving alimony provision and the proper interpretation of that. But as you said, if it is a proper interpretation that, well, that my client was required to pay indefinitely beyond the statutory duration of full retirement age, or presumably beyond that, and if that provision were to be treated as surviving, it's possible that even his complaint for modification should be disregarded. But
Well, I don't know about that. No, I think the only question that's before us is whether the judge erred in concluding that the period could extend up until the point at which she chose to stop it, right? That's the only question before us. I mean,
essentially, yes.
Prior to ceasing alimony payments, is there any reason why the husband wouldn't file a complaint for modification just to get judicial approval for stopping those payments?
Well, prior to that, obviously, George came down, and the dicta there refers to essentially a rebuttable presumption that alimony would terminate upon the payor's full retirement age. And I think he was proceeding on that basis rather than the theory that he really needed to file a separate complaint. Obviously, with the benefit of hindsight, not only would,
Sure, I'm just trying to understand if there was
but also would have, drafted the agreement substantially differently.
I'm just trying to understand if there was a strategic reason for
really,
doing that.
his reason for not doing it, I think, was just simply an overdeveloped sense of fair play. And, his consideration was that, hey, I'm continuing to work and earn money. Why don't I just keep doing what I'm doing? I can't say that for sure, but
well, that's
without
the
violating any
inference to be
privileges
drawn
and
from what you said that day. You basically said we didn't put one in, and she has a disability, and he's likely to continue to work beyond that, beyond the date in the. I don't think you said beyond the date in the Reform Act. You said he's just likely to continue to work.
Correct.
Were the words you used.
And he did.
And he continued to pay, and then at a certain point he said, well, I don't want to continue to pay anymore.
And he actually continued to work up until the point when the company he worked for was failing. And he actually continued to work without pay for 6 months prior to filing his complaint.
Okay. I think we understand. Thank you.
Thank you very much.
Good morning, Your Honors. If it pleases the court, my name is Melissa Levine-Piro, and along with my sister, Carrie Brusso, we represent the appellee, Jane Klein. We believe that this is a very straightforward matter that the trial court judge handled flawlessly. She took this court's instructions to remand the case back down to determine intent and to take into account parole evidence, and she did just that. Unlike the second case today, we were fortunate to have the transcript from the colloquy.
You were here.
I was here for that, and I found it helpful. So that was introduced. That was the one exhibit at the remand hearing. And as we just discussed, my brother mentioned, and you brought up, Your Honor, Englander, that the colloquy was really clear. So Judge Monks, the divorce trial judge, said to the counsel and parties, was it your intent to not include termination language with respect to alimony? I'm sure it was very fresh on her mind, given that the Alimony Reform Act had entered only 9 months prior. And wife's counsel answered in the affirmative that wife suffered from a disability. She's on permanent disability at the time of divorce, and it was intentional. Wife confirmed on the court, on the record, and then Attorney Clark, who was husband's counsel at the time, also chimed in that husband was likely to work past retirement age. He didn't dispute what wife's counsel had said, and he goes on to say, and it would be a hassle to file a modification. So I think it's very clear that the second appeal is somewhat a bad faith filing. It has caused a huge financial burden for my client, whose only income in 2024 was $19,994 in disability income. She was permanently disabled at the time of the divorce due to a brain tumor, and everyone was well aware of that fact. So in the judge's finding—
Did you argue below it was a bad faith filing? You're talking about the appeal.
the second appeal, this appeal that we're here on today, I did argue that, Your Honor, especially given what the colloquy shows. And I think what Judge Allen did on the remand hearing was really good. So she looked at Griffin v. Kay, and she took
So it was two different judges. It was Judge Monks and back in 212.
Judge Monks was the divorce hearing
Right.
to introduce the colloquy, and then Judge Allen heard the contempt, and then Judge Allen also heard the remand.
Oh, I see.
So she heard both of those.
I see.
So Judge Allen, on the remand hearing, took the instructions of this court and followed it flawlessly. She held a full evidentiary hearing. The colloquy comes in as the one
Followed it
exhibit.
flawlessly, and she took a couple shots at the decisions that this court had made. Why are you entitled to your fees where there's no contempt?
Because even though it wasn't, I think the way Judge Allen interpreted it was there was an order for him to pay alimony of $600 and change a week, and there was no termination date for him to stop. And by his own admission and actions, he unilaterally chose to stop it. And the only remedy available to my client was to file a complaint for contempt. And in their separation agreement, it does say if someone does not follow what is ordered in the separation agreement, the judge has a right to order fees. And I feel like she was following
Okay,
that.
so let's just, you've said two things. So let's leave aside what it says in the separation agreement for a moment.
Sure.
Okay. This court said there was no contempt.
Correct.
It wasn't for you or for Judge Allen, I don't think, under those circumstances, to go back and suggest that there was in fact contempt.
That is fair.
I mean, our court said there was, it was not clear enough that alimony had to continue past the ending that was directed by 49F.
Right.
That there was a reasonable position taken by the father, by the husband, to the effect that it ended with the Alimony Reform Act, because nobody directly addressed the Alimony Reform Act in the agreement, right? So is it fair or do you want to try to re-argue that there was in fact contempt?
I mean, I do think there was a contempt. I do think that the language of the separation agreement is clear to the point of there was X amount of dollars that were ordered to be paid weekly, and there was no termination in sight, and husband failed to follow that. He stopped paying. So I do think...
Right, but any other agreement without the parole evidence that you had would have terminated on the date dictated by the Alimony Reform Act.
But I think it's what you said earlier, that we go to
So then how can it be clear if it would have terminated without the parole evidence?
Fair.
Okay, so let's not talk about contempt, because our court's already decided it, and unless you're asking us to ignore the law of the case, you have to have another reason other than contempt to get your fees.
Sure.
So then the second reason I heard for your fees is you think that it's allowable as under the agreement itself, right?
Agreement itself.
Okay, which clause of the agreement?
I don't have it in front of me, Your Honors, but it does say that a judge can order fees when someone doesn't follow the agreement. And I think the judge has a right under Griffin v. Kay, absent a contempt finding, to order remedies.
Per an agreement. Per an agreement. Yeah, right? That's your argument. So what's the clause of the agreement? I did look at it. I'm just going to try to find it.
Yeah.
And what does the judge say more? So I need to match the agreement to what the judge said.
Paragraph 29, separation agreement, on the appendix, page 24.
Thank you.
A party who breaches any provision or obligation imposed by this agreement.
Is that what you're referring to?
Yeah, that they breach any obligation.
Other court action to enforce. including the prompt payment of all attorney's fees, costs, or expenses incurred in enforcing the provisions of this agreement. Okay. What did the judge say when she granted the fees?
Sorry, I'm just looking for that in the transcript.
'73, the court finds the defendant is breached. '74, the defendant shall pay plaintiff counsel fees incurred
Right.
without a citation to a particular reason for it. Okay.
Correct. So she ordered fees, and that we believe the fee should stand.
Okay.
We also believe that fees are warranted in this case, given that the trial court did what they were supposed to do. This isn't a second bite at the first appeal and attempting to re-argue what was argued at the first appeal. This is just to say if the judge did something wrong in her findings at the appeal. And I don't think the fact that alimony was a merging provision or that parole evidence shouldn't have been introduced, as my brother raises, are reasons for this appeal to go forward.
So you could read the prior decision from the appeals court, the latter part of it, that the alimony provision did not merge. Is that correct? You could read it that it was independent with a cite to McManus, or are you not conceding that?
You could, yes.
They initially state that it was merged, but then there's an interpretation where you could read it as a separate independent document, correct?
True, it does say like no future past, present, or alimony can be requested by either party. So that's where the ambiguity lies.
But you don't believe there's any real significance to that ambiguity due to, as Justice Englander said, the Kavanaugh decision, which you can also look to contract principles to decide ambiguity in a judgment.
Right, exactly. And that wasn't the first time with Kavanaugh that we could introduce parole evidence. That's been well established that if there is ambiguity, as this court pointed out, that it can be remanded for extrinsic evidence, including parole evidence. And in this case, that was the colloquy, which we're fortunate again to have, which showed very clear intent by my brother, who was on the record at the time, saying it was the intent not to include termination language. And we have a plaintiff, our client, the wife, who was very clearly disabled, who hadn't worked. Her only income on her financial statement at the time of divorce was her disability income, and she had already been deemed permanently disabled at that time. Perhaps there should have been written findings to clarify it so we wouldn't be here today, but I also think there's an argument that so much time has passed under the Correa case that written findings are so much waived at this point.
I also was confused by a contempt argument because although our prior decision didn't find contempt, they didn't have the information of the prior hearing.
Right.
So is that a changed circumstance where the father could be held in contempt because he was aware he was present at that hearing?
I mean, I think so. I mean, I know we don't want to harbor on the contempt issue, but I think he clearly paid. And I think one of the things Judge Allen does really well in her findings is go through the actions that the husband took post-divorce. So they get divorced, and he pays well past his retirement age. He retires at age 66 under Social Security based on the years he's born.
To his credit, correct?
To his credit, yes, he pays, but he basically arbitrarily picks a date to stop paying. So he works about a year and a half full-time post when he stops making payments to the wife. So he basically, from age 66 to 70 and a half, is paying her alimony pursuant to the agreement. It doesn't make sense to me that if he truly believed that it terminated, why he would continue to pay it. The judge also discredits his testimony at the remand hearing where he says he didn't know about the Alimony Reform Act until 2020 when he stopped paying. She doesn't find that that's truthful given that there was the whole colloquy about it through the parole evidence that was introduced. So I do think it's disingenuous to have brought this appeal saying that he shouldn't have to pay based on what was introduced at the remand hearing.
Again, I don't want to linger on contempt either, but I thought in your brief you're arguing that Judge Allen did not find him in contempt.
She did not, no, and she did not. And
I make sure that's clear.
And I'm not sure that the contempt matters for the point of this, except as it pertains to attorney's fees is the one issue, as you correctly
I don't think
point.
it does matter, except as to attorney's fees. I think it's very clear. The fact that you can't get contempt doesn't mean you still have to construe the order. And if the order required payment, then that payment has to be made, whether there's contempt or not.
Right. Exactly, and I think the judge through Gifford v. Kay had a right to order attorney's fees to remedy what she thought was fair and equitable, given the fact that he stopped paying and that it had been appealed and then remanded back down. I think she thought that the correct, to make our client whole again was to order not only the arrearage to be paid, but also affirm the original attorney's fees order. I think it was an equitability judgment in that respect, regardless of him not being held in contempt.
So your argument is essentially that husband counsel has waived objection to no written findings.
I do think he has over this point in time. I think under Correa, if you look at 816 of that case, objections, issues, or claims, however meritorious, that aren't raised at trial level are generally deemed waived at appeal. I think that argument is out the door, and I do think that there was a meeting of the minds at the colloquy. Both parties and their counsel agreed on the record that it was intentional not to have a termination date.
Do you think that even if we were to agree with even if we accept the findings of the judge here, that what was intended was payment that extended beyond and extended up until the date that the judge has determined, the judge still had to make written findings to comply with 49F, and if she failed to make the written findings, then the award could not stand?
Are we talking about Judge Allen on remand or the original? The original divorce judge?
Yeah.
I think in family court, written findings generally, as a matter of practice, aren't issued unless a case goes to judgment, and this through trial. And this case went to judgment through settlement. So I think it is very common for a judge to clarify intent on the record, confirm it on the record recorded, and accept that as the end-all be-all, and that it's not common practice. And I think in hindsight, it's easy to say that either counsel could have requested written findings, but that wouldn't have been standard practice in family court on something that was accepted as a separation agreement in which everyone agreed on the record what the intent was. So I think at this point they're waived, but I think good practice would have been to do it, but not how things are necessarily done.
You can catch your breath now.
Thank you. I have nothing further unless you have further questions. Thank you, Your Honors.
Are we missing counsel? No, we've got counsel for the sixth case. All right. The sixth case, Pagliarini versus Burkowski, and it's 24P562, and I think we'll hear from Mr. Stone first. Is that right?
Yes, thank you, Your Honor. Good afternoon, Your Honors. My name is Ronald Stone. I represent the appellant, Andrea Burkowski. I was also trial counsel in this matter. I would like to just, if I may, refer to the birth certificate issue that was raised in my sister's brief. This was a case, Your Honor, where we were told we had 1 day to try the case, and that was reiterated at the beginning of trial, and we in fact tried this case and completed it by 4:09 that day. We had 61 uncontested exhibits with the goal of, again, being able to try this case in a day. But this was a case that originated many years before, during the height of COVID in June of 2020. I am successor counsel, but I came in on December 28th, 2020. Attorney Hebert filed her appearance, I believe, on November 16th, 2022. So I think there might be some confusion as to what the obligations and the circumstances regarding the birth certificate that was part of a temporary order.
You're saying that the temporary order did not require, I'm going to cut to the chase.
Thank you.
You might have missed the opening where I said cut to the chase.
Yes.
We will have read this stuff, and sitting here, you probably get the sense that we have some questions.
Yes.
If you're saying that the temporary order did not require a name change, I agree. That's not what the temporary order required. It required that the father's name be placed on the birth certificate.
And the point I'm just trying to underscore is that there were 3 references to my client being in contempt for not seeing that name change occurred. It is not her burden. In fact, she doesn't even have the power to do it.
Not what the temporary order said?
No, not at all. It just
So
said,
when she testified at trial, she said she kind of agreed with the notion that is what the temporary order said.
most respectfully, I believe she testified that she reached out to determine if she could do it. And as I have learned in previous cases, it is through the courts and the Registry of Vital Statistics.
Maybe we're talking across purposes again. The point I thought you were going to make is that the temporary order did not require that the child's name be changed to Mr. Pagliarini's last name.
Yes. And secondly, though, that it was
You
not...
could do it or not, doesn't matter. That's not what it said.
That she had some burden to make the birth certificate indicate that he was the father, not the name change. That was never ordered. That wasn't her responsibility. There are arguments that she has delayed 3 years of the child having his name by violating the order. And
why do you think this judge made a mistake?
I don't see how this judge applied any of the articulated precedent regarding what is involved in determining whether a name change is appropriate in this case.
You mean in the written findings?
Or at all, Your Honor, because if you look at the Jones case that started in 1992, that started this whole issue regarding what a court must consider. They expressly stated that the father's surname is not to be presumed to be the minor child's. They put a stop to that in 1992. And that was the only testimony the father gave as the basis.
Well, but that's not the only evidence that was before the court, was what the father said in response to that question. There was a lot of other evidence in front of the judge that could inform whether the child should have the father's name or the mother's name, right?
But it was not articulated, Your Honor, in any of the findings.
Where does it say it has to be articulated by the lay witness father? If the father puts in all kinds of additional evidence about, I mean, the GAL reports in evidence, right?
And the GAL recommended that the name remain the same.
GAL also put in some evidence about how the mother had treated the father throughout that process, which might have suggested a concern to the judge that the mother was, in fact, I think it's articulated directly that the mother is trying to cut the father out of a relationship with the child, right?
Your Honor, there has been from...
No, but that evidence was before the court.
Yes.
Okay. And was that something that the court could take into consideration in deciding what name the child should have?
If there was going to be a decision by the judge that there was parental alienation, and as a result, she ruled that the father should have the daughter should have the father's surname, that should have been articulated in the judgment, and it wasn't. It's not even mentioned. If you look at the reasons the judge gave for the name change, they run contrary to the case law. It's not as if there was any consideration of the precedent and distinguishing it from what was before the court.
So what's our standard of review?
Standard of review is whether the trial court erred as a matter of law by abusing the broad discretion given to her.
Is it, if it's an abuse of discretion standard of review?
Yes.
Okay, abuse of discretion subsumes error of law, right? So are you saying this was just beyond the judge's discretion given the facts that were before the judge? Or are you saying there was an error of law and here's what it is, Judge? Right here is where the mistake is. Which one?
Both.
Okay.
If I may.
Then help us out.
Okay. Well, first of all, I'm saying that the judge had an obligation to address the case law and the standard and did not do that. Gave reasons that were not even articulated in any of the recent cases. The fact that he has a relationship with the daughter, that's the case law states that that's not a reason. She did not address how this would potentially harm this 4-year-old, soon to be 5, actually she's 5 years old. So
The standard is best interest of the child.
Yes.
Right?
And
under the, as informed by the three principal cases from our court.
Right.
Is that fair?
Absolutely.
Okay.
But again, they give specific direction into what should be considered and, most importantly, what should not be considered. And if I read Jones, the seminal case from 1992, it boils down to we are going to disavow the patronymic standard that has been applied. We are not going to just assume that all children should have their father's names. We're going to look at various issues with respect
But the judge was open to another name, right? I mean, open to like a hyphenated name, but
Yes, Your Honor, she did. That was one of the...
she was cognizant of that.
And that was in her findings. She's saying that the mother did not request that the minor child adopt her maiden name, which I don't see how that would be in anyone's best interest, except that her maternal grandparents have the same name. And if you look at...
I read those as two different
Burkowski, Pagliarini, or Pagliarini, Burkowski, when you're filling out, just think of the logistical nightmare that would be. If her name was Stone, then maybe that would be a different story. But practically speaking, I just don't see...
Hyphenation is denied because it has too many letters?
Yes, and when you're filling out the boxes where you have to put your surname for tests or whatever, and this girl, I just did not see that as a practical proposal. Again, we have a 5-year-old who has 2 younger brothers who are going to be in the same school with her. The mother does not teach in the same city or town.
What is the current, I don't want to go outside the record very far, but the current status is the child is in preschool?
Yes, Your Honor.
Okay.
She started preschool in September, so she's not even in kindergarten yet. And again, prior to preschool, she was writing her name as Andrea Burkowske. She was pronouncing it. She has 2 brothers that have the name Burkowski. Mother has custody in accordance with Cormier, even though it's not, the court did not adopt the standard that there will be a presumption, certainly is a factor. And if you look at all the factors enunciated, coupled with the fact that the father's sole testimony was that 99% of all kids have their father's name, when that's expressly a reason why a name change should not occur, I respectfully assert that the court did not apply the appropriate precedent and weigh the appropriate factors, and this was an abuse of her discretion. As a result, this is reversible error. And I'm asking that the court reverse the name change and have it remain as it always has been.
I still would like to drill down a little on what the legal error is. I hear you saying, look, there are factors. There are some things that you can't consider. For example, you can't say the presumption is the child should be the father's last name. Can't do that, right? Court didn't say that, right? The judge didn't say that.
But if you look at what the judge did say, Your Honor, that's where my issue lies. And it is 3 lines. The court finds that it is in the child's best interest that she have the last name of her father, not her mother's husband's last name. Although she has the mother's current last name, there is no request for the child to be given mother's maiden name, nor has either party requested a hyphenated name, which the court would have considered. Since mother assigned last name Burkowski, it has been determined that Donald Pagliarini is the child's biological father. Child has developed a relationship and a parenting schedule. The court finds that as a result of the above, it is in the child's best interest to change the child's last name. That's it. There was a recent
can I just say, I'm sorry, this is all my fault. This case is partially impounded. We should stay away from the names.
Oh,
Okay?
I'm sorry,
Let's just
Your
use
Honor.
child, mother, father.
I apologize.
Okay.
I've never had...
I think I'm responsible as well, so, okay?
I apologize. I won't do that again. In any event, Your Honor, case that just came down in July, it was affirmed because the judge did in fact weigh the positives and the negatives of the name change as this court articulated in the Gomes decision in 2021. We don't have any of that. none of the considerations, none of the articulated analysis. It's not there. And again, if you look at the fact that there were findings regarding the mother's alienation, denial of the pregnancy to the father, this has been a case where he has had parenting time with a minimum of 2 times a week since January of 2021. Actually, the order was March, but we had started doing visits prior to the order. So in his
counsel, child, mother,
I understood.
father.
But my point is that I see you referred to these issues that were mentioned in the judgment, and I'm saying that they were not even addressed in the judgment with respect to the name change. And I'm asking that if you weigh the factors, you weigh the GAL's recommendation, you weigh the mother's testimony that conforms to the case law as to why this not only is in the minor child's best interest, but that it would be detrimental to her to have a different surname. I believe that the judge, again, abused her discretion and erred as a matter of law in ordering the name change. Thank you.
Thank you, counsel. We'll hear now from Father's counsel.
Good afternoon,
Ms.
Your
Hebert,
Honors.
is that right?
That is correct,
Aye.
Your Honor. May it please the Court? Mandy Hebert on behalf of Donald Pagliarini. So I'd like to start off at Jones. And counsel just talked about the fact that Jones was on point to this case at bar, and that father's name should not be presumed to be the child's last name. But if you go in to read and really pull apart Jones, the most important thing it talks about as it relates to this case and throughout the other cases is that further consideration should have been looked at, and they didn't find this in the Jones case, is the effect the change of the name the child would have on a bond with either parent. That's key to this case here. So if we look at...
Jones uses the word bond to the parent?
Bond to either parent, correct. And if we start off...
But the judge doesn't talk about that, right? We have no findings on that issue at all from the judge.
I don't agree with that, Your Honor, and I will tell you why. Because if you look at the judge's findings, she starts off by talking about the court does not find mother's testimony credible that she did not contact father, learning she was pregnant because she believed the child to be her husband's baby. She goes on to say the court finds that both prior to and after the genetic marker testing, mother was reluctant to begin and support a relationship between the child and the father. The court finds that mother made allegations about difficulties with father's parenting time and transfers to limit or decrease father's parenting time, contrary to the best interest of the child. The court credits the GA testimony and observations that the minor child has bonded and has formed attachments with the father without emotional distress.
Why do any of those things suggest that the judge considered the bond, the relative bonds in determining what the name of the child should be? Because the findings are very spare on the name.
I understand that, Your Honor, but if you look at how she sets that out, she sets out as enumerated above. You could take that context of all of her findings, everything she heard about this trial, everything she heard.
What do you mean as enumerated above?
So if you look at, and I might have, KK on page 9 of 9. The court finds that as a result of the above, it is in the child's best interest to change the child's last name to that of her father. I would suggest that the findings that she was making throughout led her to believe that these are the reasons why this child's last name should not be mother's last name.
Can you point me to where in her findings she discussed the impact on the child? For instance, Jones lists one of the factors as a judge should inquire perhaps of what impact the name change would have on the child at school or with others. And this child may be going to school with siblings who may have a different last name. The judge never really focuses on the impact to the child. It's more focused on the impact to the child and parent, or the parent focus.
So the impact of the child as it relates to the siblings, very simple. Mrs. showed up to court pregnant with another child. That child was born, I believe it was March of 2024. At this point in time, the child is 4 years old. We have another child that was approximately 2 years old. When the oldest, the child at the case, when she heads into school, she's going to be above and beyond the two younger.
Yeah, the two younger are going to be 2 years behind and 4 years behind.
Understood.
So so I think you're getting to answer Judge Smith's question, but where did the judge consider whether or not that was going to have an impact on the child?
She didn't, Your Honor. She did not rule, she did not come out with findings.
Isn't that something, I mean, isn't that sort of the most, I'm not going to say the most obvious, I started to, but that's not fair. But isn't that clearly a consideration? I mean, the mother testified to it, and isn't that a consideration the judge should have addressed?
That is something that the judge should have addressed. But if you look at the facts of this case and how this case was handled, and you look at a case like Gomes, where the father actually went and signed the birth certificate using the mother's surname, saw it was on there, signed off on it, and was fine. My client was completely shut out of even knowing he had a child that was born. He had no idea whatsoever.
And all right, so that's an answer to the question why. I mean, the one thing that is clear is that the law is the best interest of the child. Whether the father was shut out, whether the mother has misbehaved, those are in the findings. Those are things that are relevant to the judge's determinations with respect to perhaps things like parenting, et cetera. But when we're talking about and looking at the case law, it's the best interest of the child, right?
Understand.
And so don't we need to see that?
Well, with respect to the best interest of the child, Mrs. also testified that the child should have the same last name as her father, Carl, who is not her father.
She meant as the
That's
person
very-
that the child knows as her father, right?
It's very concerning. Again, throughout the findings, you see that this mother tried to alienate this child from
Okay.
her.
Okay, so if that's true, are you saying that it was the mother's misconduct that basically impaired the judge's ability to view a larger picture of what was in the best interest of the child?
That's not what I'm saying. I'm saying when you look at the test itself, because it's a standard, the best interest standard, did she perhaps miss some of the standard? I don't disagree with you, but a fundamental part that she hit on and talked about throughout her findings is that mother was systematically trying to remove father from this child's life. And for this child to then not have her actual father's last name, that is not going to be in the child's best interest, because every step of the way throughout this litigation, she did everything she possibly could do to undermine him in this child's life.
The problem with that is the judge is also entering an order that squarely places the child in the father's life and the father in the child's life, because it's saying there's going to be irregular parenting meetings, and they're going to exist, and they're going to exist every week, right? That's the whole first part of this order.
I understand that, Your Honor, but if you go back to, and I'm going to go back to Gomes, where the court decided to reverse the judge's decision regarding the name change. In that particular case, not only did the father sign off on it, but mother testified that they had a very good relationship with their dad. Their dad was, they knew who their father was, and they loved him very much. Throughout this litigation, throughout the testimony, Mrs., as is written in the findings, undermined father. He was not a good father. He scared the daughter. He was, I mean, it says it in the findings. And so in Gomes, it didn't hurt to not have the last name, but in this particular case, it's going to really hurt this child if she's differentiated even more between who her real father is for her own health.
How does it help the child have the father's last name? In this case, how does it help the child? And so answer that question and then say, where does the judge articulate that in the judge's findings?
It helps the child so that she has a clear understanding, irrespective of what's being said about father and who he is. She has a clear understanding that that is her dad. That is very important as she goes through life. And the guardian ad litem hit on it and said that if the mother and her husband don't get on board with this, the child is going to suffer in the future, suffer significantly. And the judge is imploring them to get on the same page. Otherwise, the child will suffer.
I didn't see any findings.
So,
I didn't see any findings about the husband, just findings about the mother.
It says, HH, mother and her husband need to better accept father and his place in Elsa's life. Mother and her husband's acceptance of father will benefit the child, in essence. Accepting the father. If they can't accept the father, where does that leave the child? That is not in the best interest of the child. It is more confusing to the child. It's going to lead to a lot of issues in the future for this child.
Okay. You have anything more for us?
No, sir.
You guys have a question? Thank you very much. It's a difficult case, as I'm sure everyone knows, and we will give it our most serious consideration. Thank you.
Thank you, Your Honor.
Oh, yeah. That ends today. Thank you, all the folks in the courtroom, security, timekeeper.